Morning, everyone. The inquiry's resumed. Are there any housekeeping matters before we move on? No? No. No. Any housekeeping matters, Mr. Humphreys?
Just one update, Madam. I think a draft of the modification statement should be available this afternoon. I think it's available now, but Ms. Reynolds just needs to carefully check through it, but that should be available this afternoon.
Thank you for that. Do you want to introduce your witness? But he doesn't seem to be here. Oh, he is here. Right.
So, Madam, I'll just firstly introduce the witness. Is your name Bernard Greep?
It is.
And you tell us in your proof of evidence that you are a planning director at Stantec and that you head Stantec's Manchester office. And you then tell us in your section 1.2 about the scope of your instructions when you were instructed, and you also touch there on the issue of having reviewed the facts and the background to the case. You came to the conclusion that MPPF paragraph 115C applies in relation to whether or not this is inappropriate development in the Greenbelt. Is all that correct?
That's all correct, yes.
And we will obviously return to Greenbelt issues later. Mr. Greep, I want to start by just taking you through, in effect, section 3 of your evidence, which is the planning policy assessment, and in particular in the context of section 38(6), and the inspector will see from having read that you draw in many places on the local planning authority, the OCC local planning authority officer's report. Is that correct?
That's correct, yes.
And we have that document, Madam, as CDF1, and the relevant part starts at PDF page 17. We may need to dip into it. But what was the ultimate recommendation from the OCC planning officers in respect of this application?
The overall recommendation was that the application should be approved.
And in your section 3.2, you identify for the inspector the adopted development plans, the relevant development plans both in South Oxfordshire and the Vale of the White Horse, and there's also a great big long list on pages 9, 10, 11 and 12 of the proof of relevant policies. And in carrying out your assessment, have you considered the development against those policies where relevant?
I have, yes.
And your section 3.3 then deals with the consistency of the development with the development plan, that is call-in matter C, and you deal with this, it's a long section, but you deal with it under a number of subheadings relating to all the principal policy issues, and I'm not going to get you to deal with absolutely all of them, but there are some that it may be worth getting your views on just to expand for the inspector. And the first one is the principle of the development, which starts at your paragraph 3.3.3 and continues to 3.3.11. Again, just a high level, Mr. Greep, for the inspector, just summarise your position on the policy context for the principle of this development going ahead.
Okay, well, I think it's summarised in 3.3.11. In summary, the principle of the scheme is fully compliant with the development plan, and the development plan is fully up to date. That was my view.
Sorry, can you just talk a little bit slower on that? Can people...
Okay,
yeah.
I'll start that again.
Yes, just so the inspector can take a note.
Okay, so I think in summary, my conclusion is that the principle of the scheme is established and is fully compliant with the development plan, and the development plan is fully up to date in my view. That was the view I reached when I conducted my initial review. That's the view that each of the officers has reached in the inquiry, and that was the view that the officers took when they drafted their committee report.
And in this section of your proof, do you identify the relevant passages in the officers' report and also the relevant policies to support that conclusion?
I do, and I don't propose to go through them all now. They're all there in the evidence, but yes, I do.
The next subheading is at 3.3.11, and that deals with Greenbelt, but we're going to postpone, I suggest, discussion of that because it's dealt with in considerable detail later in your evidence. But moving on, the next issue you touch on is transport, that starts at 3.3.14. And again, perhaps you just explain your view on the compliance of the development with policy in that respect.
Okay, I suppose what I should say at the outset is for each of these different policy topics I've relied upon the expert witness of the various experts. So in this particular case, the likes of John Disley, etc. And what I've sought to do in each of these sections is summarise the evidence from those particular witnesses. And I've also extracted key parts of the committee report and then ultimately summarise what my view is based on all of that. And it's at the end of paragraph 3.3.17 where I highlight this extract from the committee report. The application is therefore considered to be in accordance with various policies in the adopted development plan and also national transport policies. So in summary, it's in accordance with all of that.
And that's your conclusion?
That's my conclusion, yeah.
And then landscape and visual impact, and this is a topic where you do find that the scheme is not wholly compliant with the relevant development plan policies, and so I'd just like you to again take the inspector through that. She will have read it, your proof obviously, but just to summarise why you come to that view.
Well, again, there's quite a long commentary in the proof. I won't go through all of that now, but I think it's inevitable with a scheme of this nature, which is in a rural context, which passes through open land, that inevitably there will be some degree of impact on landscape, and that's my conclusion in summary. And that draws upon the conclusions reached by Jane Ash, and again, I've summarised all of that in this section of the proof and also the relevant sections of the committee report, and no doubt we'll come back to this in more detail later on.
Thank you. And obviously the ultimate judgment has to be on whether the development is in accordance with the development plan as a whole, and we'll come to that, but we need to recognise that in this respect you say it's not completely in compliance. The next topic is design and layout, and there are a number of them here where, perhaps without being tedious, we can take them fairly shortly. So design and layout, and then air quality, noise and vibration, biodiversity, flooding, climate change, and water quality and pollution. I'll stop there because I want to ask you about cultural heritage, but in relation to all of those topics, again, do you summarise the evidence of others and then form your own conclusion? And what is your own conclusion in relation to each of those in relation to compliance with development plan policy?
Okay, well, I won't go through each and every one of them in separately, but in summary, my conclusion is that in each case the scheme is in compliance with the development plan and also with national policy.
Cultural heritage, this starts at paragraph 3.3.52 on page 27 of the proof, and again there you summarise the position from the committee report in paragraph 3.3.53, and what is your conclusion about whether or not the development is in accordance with development plan policy in relation to cultural heritage?
Okay, so again, quite a long section to read, but in summary, it's at the top of page 29 of my evidence. I conclude that in this regard, the scheme is in accordance with national and development plan policy.
And insofar as we deal with national policy, looking at 3.3.54, and you've taken into account there the heritage technical note of Dr. Scott, and you refer there to less than substantial harm to the setting of Fullermoor Farmhouse, the Grade 1 listed Newnham Courtney Registered Park and Garden, the Newnham Courtney and Clifton Hampton conservation areas, and the scheduled monument through urbanising effect and changes to setting. But it then says, however, notwithstanding the great weight and importance that's attached to these designated assets, the public benefits arising from the development as set out elsewhere in the report weigh heavily in favour of the development and offer support to the proposal that outweighs the harm, and it then also talks about the non-designated assets. And in that regard, how then do you draw the balance in the NPPF paragraph 208 requirement to balance benefit against less than substantial harm to heritage assets?
Okay, so as you say, paragraph 208 of the NPPF say, it's probably worth me reading it out in full.
Yes.
For everybody's benefit. It says, paragraph 208 of the NPPF says, where a development proposal will lead to less than substantial harm, i.e. in this case, to the significance of a designated heritage asset, or I suppose it should say all heritage assets, this harm should be weighed against the public benefits of the proposal, including, where appropriate, securing its optimal viable use. Well, in this particular case, there are a series of conservation areas, and the heritage witness has gone through each and every one of those and ascribed a degree of harm or effect in relation to each of those, come to a conclusion that overall and individually the degree of impact is less than substantial harm. So that's the conclusion reached by the heritage expert, which I've taken on board and accepted. And then what I've done later in the proof is weighed that level of harm against the range of benefits, which we'll come on to later on.
Fine. And then you go through other topics, minerals and waste, agricultural land, recreation, and geology and soils. And at paragraph 3.66, you deal with the test, which is summarised in call-in matter C, the extent to which the proposed development is consistent with the development plan for the area. And we know that from case law that is, you look at the consistency with the development plan as a whole, and what therefore is the conclusion that you invite the inspector to draw in relation to that issue.
Okay, well, it's summarised in 3.69 of my evidence, and my conclusion is that the scheme is consistent with the development plan when read as a whole, notwithstanding the limited degree of of conflict with the landscape policy.
We know, however, as a matter of law, we have to go on and consider other material considerations, and you do that in your section 3.4, and you identify some of them here. We need to note at your paragraph 3.4.2, you make clear that other material considerations also include the significant and wide-ranging benefits arising from the scheme, and you describe those in section 6 of the evidence. So they're not all set out here because they're dealt with in the context of Greenbelt later. But in that context, that those benefits are acknowledged here but dealt with later, you then look at other material considerations in terms of national planning policy, planning practice guidance, and then various draft local plans. And again, perhaps in that context, the draft plans and indeed plans that are not part of the development plan, for example, the Didcot Garden Town Delivery Plan. What's your overall section 38.6 conclusion?
Well, overall conclusion is that the scheme is compliant with and in conformity with all of those documents. There's one supplementary point, I think one of the officers yesterday mentioned that one of the, which I've listed in 3.4.2 as a draft neighbourhood plan, is now close to becoming a made neighbourhood plan.
Yes.
But notwithstanding that point of detail, in summary, yes, the scheme, in my view, complies and is in conformity with each of those documents.
Thank you. Now, we turn in your section 4 to deal with paragraph 155C of the MPPF, and you do reproduce it there, but maybe we should open core document G20, which is the current version of the MPPF, because we may need to look at it in one or two contexts. And if we turn to PDF page 45, that's actual page 45 as well, we can see paragraph 155, and we'll be going through those tests in a few moments, but the issue here is whether we fall within 155C, local transport infrastructure, which can demonstrate a requirement for a greenbelt location. So that's the context, we'll come back to it. Let's just look first at the Greenbelt boundary, if we may, and we need to go to your appendices, and in your appendices turn to Appendix 2.2, and the particular page is at PDF page 48.
Sorry, did you say page 48?
Yes, PDF
Okay.
page 48. It should be, Madam,
I've got
plan.
it. Thank you.
And this conveniently identifies for us those parts of the overall scheme that are within the Greenbelt. And we'll come on to talk about the detail of that later in the context of the purposes and openness, but just noting where it is, we can see that the Greenbelt starts at the southern edge of the River Thames and travels north, and so that part of the viaduct between the southern bank of the River Thames and the A415 is that within the Greenbelt.
Sorry, did you say north to the north or to the south of?
To the north. So
to
from the southern bank of the Thames north to
Okay.
the east-west road, the A415.
Okay, so the section to the north of the Thames is within the Greenbelt.
And we can see that in that section, parts of the road are in the Greenbelt and parts are in the what is now a Greenbelt inset. So, for example, the roundabout at the top of the viaduct is not in the Greenbelt.
That's right.
And again, when we come closer to Culham, slightly to the east, and the Culham campus, and the entrance to the Culham campus there, we can see that much of that is not in the green belt. And again, as we follow along the road along the side of the Culham campus, part of the application site boundary may be in the green belt, but much of the road will not be in the green belt. But we then eventually get just above the words Clifton Hampton, we see a section of the road which clearly is in the green belt on the road out to the Golden Balls roundabout. And can I just get you, we can see the extent of the inset and the inspector can see this. Could you just take out or bring up on the screen the South Oxfordshire local plan? So this is document G.01.
Okay.
And I'll get you to turn, if I may, to PDF page 226.
That's picture.
That's the green belt, inset green belt boundary at Culham.
226.
Oh, sorry, madam.
I think I've got the same page as
No,
the
no,
inspector.
no.
Yeah.
It's 262, madam.
262.
It's my usual trick of my slight number dyslexia of swapping the last two numbers.
Thank you.
I'm so sorry. 262.
Okay.
And we can see there cross-hatched is the Greenbelt inset, and again one can form the judgment of what parts of the scheme in that area are within the Greenbelt and which are outside the Greenbelt, and one can sort of judge. You can see the Thames Water sewage treatment works, and the little piece of land north to that, and then beyond that is in fact not in the greenbelt, it's within the inset. Do you see the sewage treatment works?
Yep.
So clearly we need to, informing views about purpose and openness, we do need to recognise, don't we? It's important to recognise what is and what is not in the greenbelt.
Absolutely, yeah, we do.
And in your proof of evidence, at your table 4.1, which is on page 38, you set out a table of the land requirements within South Oxfordshire and the amounts of the overall land take that are actually within the green belt.
That's right.
So when one is obviously considering the extent of the scheme and whether this is local transport infrastructure, is it relevant to bear in mind what we're talking about the development in the greenbelt?
It's very relevant because the tendency is, I think, to categorise the scheme as passing through the greenbelt and automatically assume that all of it passes through the greenbelt. That's absolutely not the case, as we can see from these tables. It's probably useful, I think, for the inspector and everybody else's benefit for me to just briefly run through what's actually in these three tables, tables 4.1, 2 and 3.
Yes,
I think that would be quite helpful.
That would be very helpful. And 4.3, which I was going to take you to, is the overall land take, and the inspector can see there, you know, the overall percentage of land within the greenbelt which is permanently required as opposed to temporary.
Yep. Okay, so probably these tables are quite complex, so I'll just summarise what's in them just for everybody's information. So what we've done in the first column is to set out three things. Firstly, the permanent land take, so the land that will be permanently required for the scheme. The land that is required on a temporary basis, that's the second row, and then all of the land, all of the land within the overall planning red line boundary. And then I suppose there are three different sections of the table to the right of the first column. The second and third columns identify the total hectarage, so the land area, that's the first column, and then the third column specifies the percentage based on that land take for each category of land, so permanent, temporary, and the land within the red line boundary. So you can see that in the third column, the figures add up to 100%. So all of the land, as you'd expect, is within the red line boundary.
So can I ask you that you said all of it adds up to 100%?
Yeah. But
that 100% isn't the permanent and the temporary, is it? There must be something additional.
Yeah, so this is I've set this out somewhere, just try and find the relevant text. Trying to find it immediately. Can't find it immediately.
You've got, is it your paragraph 4.22, 4.2.2? Is that?
Yeah, so 4.2.2 says the tables are broken down into those three components. So permanent land, as I've described, the temporary land, and the planning application red line boundary. So I think this is the point you were referring to there, Madam. The land area within the planning application boundary is greater than the sum of the permanent and temporary land take, and the reason is because the red line boundary also includes some land that's needed for things like access rights associated with the scheme, etc.
Right. And then the other thing I just want to clarify, when you're using permanent land take and temporary land take, you're talking about the scheme in planning terms, you're not talking about
CPO land.
Absolutely, yeah, in planning terms, yeah.
Okay.
So if we look at table 4.3, and we can see there the total land take for permanent land, temporary land, and then the red line boundary, and you've just clarified that particular point for the inspector, and then the percentage of the red line boundary. And the third column of figures there is land within the green belt hectares, and permanent land take is 24.81 hectares, temporary 7.78, and the total within the red line boundary green belt land is 38.4. And the next column is the percentages, and perhaps you can just explain that. So what percentage of the overall scheme is a permanent land take within the green belt?
Okay, so just for clarity, this is the overall land take across both districts, South Oxfordshire, South Oxford and Vale of White Horse. And what we've got there is permanent land take of about 16%, temporary land take of about 5%, and then allowing for other things like access rights, etc., just under 24%. So just under 1/4 of the land required for the overall scheme is within the green belt.
And part of that is temporary.
And part of that is temporary. So I could have taken the view actually to focus solely on the permanent land take, but I haven't done that. I've actually taken account of permanent land take, temporary land take, and associated land required to take the worst case view, I suppose, which is just under a quarter of the scheme.
Now, if we just return to the MPPF and back to PDF page 45, paragraph 155, I just want to identify the 4 issues that we need to consider and which you consider in your proof. So reading through it, it says certain other forms of development are also not appropriate in the green belt, and then the first 2 of them, provided they A, preserve its openness, and B, I'm adding the letters, do not conflict with the purposes of including land within it. So openness and purposes we need to consider, and then criterion C here is these are local transport infrastructure, so that's the 3rd element, which, the 4th element, can demonstrate a requirement for a green belt location. So those are the 4 elements of the mix, aren't they?
That's right, yep.
And we'll come on, obviously, to consider each of those. Now, in your proof, what you do at your section 4.3 in order to inform your assessment here is to consider various other decisions on paragraph 155C as it now is, and that's on your page 40, 41, 42, 43, and on page 44 you get to your paragraph 4.3.18 and following, where you identify the implications of all that from your analysis of other cases, the implications for the scheme. So again, perhaps I could invite you to just take the inspector through that. What are the lessons to be learned when looking at paragraph 155C?
Okay, so as you say, I've set out a range of appeal decisions, and each of them is contained within my appendices volume don't propose to go through any of them in any detail. But what I've sought to do in 4.3.18 is just summarise the key principles to flow from those decisions when considered collectively. And there's 3 or 4 of them. The first, it's a series of bullet points beneath 4.3.18. The first of them is, I suppose it's the first sentence, the term local should be given meaning. And what that effectively means is schemes which are not part of the national road network, so something connected with a motorway, for example. So in this particular case, we've got a road scheme which is local. I don't think anybody at the inquiry has disagreed that it constitutes local infrastructure. So that's the first principle, I suppose. It's a local scheme. And then I'll jump to the third one, because the third bullet, because this talks about schemes which serve private interests alone. Now, some of those appeal decisions offer schemes which do relate specifically to a private interest. Now, they're distinct from schemes which are in the public interest, such as this. And that's the key distinction. Schemes which solely serve a private interest, or schemes which are in the public interest. And then if I jump to the final bullet, and I think this is a critically important one, and this flows from one of those appeal decisions which is referred to as the Hingston decision. Now, the Hingston decision is critically important for a variety of reasons, but also because it's a Secretary of State decision. Some of the others were appeal decisions, but not Secretary of State decisions. This was a Secretary of State decision. And there are a few things in that particular bullet which are critically important in this particular case. So the first one is, as I've said at the start there, development does not have to be small scale. That was the conclusion reached by the Secretary of State in the Hingston decision. Development to constitute local transport infrastructure doesn't have to be small scale. And then Secretary of State went on, and critically, it's the 4th line down. The Secretary of State actually said the schemes such as park and ride development, and critically, new transport routes. That's the key point, I think. New transport routes, and then a range of other things as well, can constitute local transport infrastructure.
And you've, for that bullet point, particularly relied on the Hingston decision, as you made clear, and for the inspector's benefit, you summarise in some detail the Hingston decision in your paragraph 4.3.4 through to 4.3.10, and you also append it as your BG 2.3c. Is that right?
That's right. Yep.
So the inspector, you've highlighted relevant bits of text.
3C, did you say?
Yes, BG 2.3c.
There's just one other supplementary point to make in relation to the final bullet beneath 4.3.18, and it was the point about, it's the penultimate line, and also structures or buildings of some sort. So what this decision is basically saying is local transport infrastructure doesn't have to be small scale, and it can encompass new transport routes, and it can also include buildings or structures of some type.
And we can see that the Hingston decision, Secretary of State decision, was a recent decision, 2020.
That's right.
Fine. Now, having identified those principles, let's then assess the scheme against the 4 criteria that I mentioned, and I'm going to take them in a different order to the one I identified with them. Let's start with local transport infrastructure, whether this is local transport infrastructure, and in your proof you deal with this from paragraph 4.3.20. Second line, scheme will provide new transport route which is of local rather than national significance. So just take the inspector there through your rationale, your working in relation to this particular issue.
Okay, and again, it's quite a long section of the proof, so I'll try and be as brief as I can. But 4.3.20, I suppose the key point there is the penultimate line of that paragraph, and it's the point about the scheme being accessible to the public at large. And I say that's one of the principles that flowed from those appeal decisions, and critically the Hingston decision. So this particular scheme quite clearly serves the public at large.
And in 4.3.21, you, again, this is in the context of this being local transport infrastructure, you make the point that the scheme is safeguarded in the two local planning authorities' development plans.
That's right, yeah.
And again, how is that relevant to whether or not this is local transport infrastructure?
It's local transport infrastructure in the sense that it's embedded into local plans, which by definition seek to make provision for local development and infrastructure to support that development, as opposed to a motorway, for example, which might pass through quite a number of local authorities.
And yesterday, Ms. Bauman made it very clear that she agrees that this is local transport infrastructure. Then the second of the tests is in paragraph 155C, is the requirement that the development itself requires to be in the greenbelt, and you start to deal with this in your paragraph 4.3.22. So in terms of the second limb of paragraph 155C. So again, just take the inspector through your working on that.
Okay, so 4.3.22, what we've sought to do there is summarise the relevant extract from the committee report from July last year, and I've reproduced paragraph 280 from that report. I won't read it out in full, but this was the conclusion reached by the officers. About halfway down that particular paragraph, it says all reasonable alternative routes connecting Didcot and Fulham would need to travel through designated greenbelt. Similarly, Clifton Hampton Village is surrounded by greenbelt, and therefore all reasonable alternative routes for a proposed bypass that enables travel between major roads would need to travel through designated greenbelt. And then it goes on, the last sentence, it is therefore concluded that the proposed development does represent local transport infrastructure which can demonstrate a requirement for a greenbelt location. So that was the view reached by the officers last July, the local authority planning officers. I think the local plan officers who have appeared at the inquiry have expressed a similar view, and in fact Alan James concluded the same as well.
And the third criterion I'm going to touch on is openness. Now, of course, openness is an issue you deal with in detail in section 5 of your proof when you're looking at harm to greenbelt and very special circumstances and so on. So we need to bear in mind there's more detailed text on openness, but in the context of paragraph 155C and the 4 criteria there, you deal with openness at paragraphs 4.3.24 and 25. So just again touch on that if you would, and explain to the inspector your views. Okay.
I think the key point to highlight here is about halfway down 4.3.24 of my evidence. What I've said there is the existence of criterion C means that it must be possible for some development to come forward within the green belt, which by extension means that a degree of impact on openness can be tolerated. So if I just pause there, it's really easy for opponents to schemes in the green belt to say, well, actually, any development in the green belt will instantly undermine the openness and therefore won't preserve the openness. And that was the view taken by Alan James particularly. He expressly said, any development in the Greenbelt will not be able to preserve the openness. Well, that can't be the case, because if that was the case, then criterion C of 155 in the NPPF would be self-defeating. You would instantly fail 155C. So by definition, it must be possible to have some development in the Greenbelt, which is local transport infrastructure, whilst still preserving the openness of the Greenbelt.
And in that regard, Ms. Baumann yesterday very fairly acknowledged that it's a matter of planning judgment. Clearly we have your planning judgment on this, but when one looks at the nature of the development of this scheme, the part of this scheme that is actually in the Greenbelt, so part of the viaduct above the southern bank of, north of the southern bank of the River Thames, and parts of the Clifton-Hampton bypass, particularly as it goes out to the Golden Balls roundabout, in terms of both the visual aspect of openness but also the spatial aspect of openness. For example, with the viaduct, will walkers or others be able to move freely, subject to the public rights of way, move freely below the viaduct?
In summary, yes, they will. And I think there's an important distinction to be made here between this type of scheme, i.e. a bridge, effectively, and built development such as residential schemes or employment schemes, sheds, commercial schemes, etc., which are monolithic structures which have some scale. We're talking here about a bridge, which, as you say, you'll be able, people will be able to see through, under, over, etc.
And in terms, therefore, of both movement and views, to what extent is openness compromised in your view?
To a very limited extent, and again, we have to take the scheme in context. So, as I've outlined, approximately a quarter, or just under a quarter of the scheme is within the Greenbelt. So it's that part of the scheme north of the Thames, and it's a bridge scheme as opposed to more bulky structures, as I've just described. And I think Miss Ash, in her evidence, described the impacts as highly localised, or very localised. So it's all those factors in totality that one needs to take into account when considering the degree of impact and openness.
And then the fourth of the paragraph 155C criteria is purposes of the Greenbelt. And I think here the only purpose that is said to be engaged, and these are the purposes in paragraph 143 of the MPPF, so CDG.20, paragraph 143, and that's PDF page 42, safeguarding the countryside from encroachment. And again, we're still in examining whether this is inappropriate development in the countryside for the present purposes. Looking at that criterion, again, what's your conclusion in the context of those parts of the development in the Greenbelt and the nature of the development that's in the Greenbelt?
Okay, so my view is there is no conflict with the purposes outlined under 143 of the MPPF. So that's a different position, I acknowledge, from the position taken in the planning statement, and indeed in the committee report last July. But the reasons for that are set out particularly in my paragraph 4.3.26, and it's at the top of page 46, I suppose. So I explain why I've reached that view, and then 3 lines down I said, don't agree that there is any conflict with the Greenbelt purpose. And then I go on to say, it cannot be right that some encroachment on its own will be sufficient to disapply paragraph 155C, and then any other approach would render paragraph 155C so narrow as to be useless or self-defeating. So again, just to pause there, it's very easy to say any development in the green belt instantly encroaches into the green belt and therefore doesn't comply with the 3rd purpose under 143 of the NPPF, safeguarding the countryside from encroachment. My view is, because of what 155C says about local transport infrastructure being acceptable in the green belt subject to those tests that you outlined, it's not the case that automatically any development in that location conflicts with the encroachment test or the encroachment purpose. So I've reached a different view to the officers. I'm quite open about that.
And so you come to your overall conclusion at your paragraph 4.3.28, that's on your page 47. You say, for all the reasons outlined above, you're of the opinion that the scheme falls within the terms of paragraph 155C of the NPPF, the approach taken both by the Inspector and the Secretary of State in the Hinkston decision are instructive in setting out the key considerations. Just in relation to that, is there anything that you have heard in the inquiry that causes you to change that conclusion?
No, there isn't. What I should add as well, I suppose, and we possibly should have touched on this at the start of my evidence in chief. When I was originally instructed back in, or approached back in August last year, I was asked specifically to consider whether very special circumstances existed for the scheme. And then I was formally instructed in October, and that was my initial instruction. So what I could have done is produced a proof, because I did form that view, that the scheme clearly constitutes a scheme which, very special circumstances exist. So I could have drafted my proof on that basis, but then actually when I started to think about it and started to draft the evidence, and then I did the research into those appeal decisions, some of which I was already aware of, including Hinkston, I formed the view that actually the scheme is capable of support under 155C. Didn't need to do that, could have just proceeded on the basis of VSCs. But actually, my view was that the scheme constituted a 155C local transport infrastructure scheme. So as I say, we probably should have touched on that at the start, but I thought it was useful to outline all of that. What then happened in early January, I think it was the 11th of January, is we wrote to the inspector to make the inspector and other parties aware of that position. And the reason for that was because the committee report and the planning statement last year didn't really go down that avenue. They focused on the very special circumstances case, which I also deal with, but I've added a supplementary consideration, which is whether the scheme should constitute a 155C. And
you then go on in that section of your proof at 4.3.29 and 30 to acknowledge, obviously, that this is a matter of planning judgment and that officers have formed a different view, and at 4.3.30 you again acknowledge that obviously the Inspector and the Secretary of State could form a different conclusion to you, very fairly. You acknowledge that, and so you then go on in your sections 5 and 6 to consider the tests for harm to the greenbelt and any other harm, and then very special circumstances.
That's right, and I think it's essential to do that because I think somebody, it might have been Alan James, used the phrase hedging my bets. Well, I haven't hedged my bets. What I've done is, as you've outlined there, and as I've outlined in 4.329 and 4.3.3, outlined my conclusion, which is that, in my view, the scheme is capable of support under 155C. But then I acknowledge, as you've just outlined, that if the Inspector and the Secretary of State decide otherwise, then it's right and proper that consideration is given to whether very special circumstances exist, which is why I then go on to consider that later in the proof.
So section 5 of the proof, first of all, you start to look at harm to the greenbelt, and section 5.2 on page 48, the first subheading under that is impact on openness, and the second on the next page is impact on the purposes of the greenbelt. And although you deal with it in more detail here than you did in section 4, we have, I think, covered your views on openness and purposes, and that's helpful. Section 5.3, you look at any other harm, and there you go through the various topics of cultural heritage, landscape and visual impact, biodiversity, noise, and so on. And at page 53, which is paragraph 5.3.13 and 14, you come to your overall conclusion on any other harm, and high-level broad terms, what was your conclusion on that?
Okay, well, as it says in 5.3.13 and 5.3.14, there are some limited harmful effects, but overall, my view is that the benefits which we'll come on to vastly outweigh those harmful effects.
And then finally, your section 6 looks at benefits of the scheme and very special circumstances. 6.2 is you deal in detail with housing growth, and this is a section where you're very much aligned with Ms. Bowerman's views as well. 6.3, economic and employment growth. 6.4, highways. 6.5, biodiversity net gain. 6.6, noise and vibration. And then section 6.7, you get to your summary of harm and benefit, and 6.8, conclusions on very special circumstances. So again, if you would be kind enough just to sort of very briefly summarise where you have ended up on those issues.
Okay, well, I could just read out the summary, but I do think it's useful actually to briefly touch on the benefits that are summarised on page 62 of the proof.
Yes.
I mean, rather than just saying actually, look, the benefits outweigh the harmful effects, it's really, I think, really important to go through these benefits almost one by one. So there are huge benefits. I think somebody back in February described the economic benefits. I think the phrase was mind-blowing economic growth at Science Vale. So the economic benefits are quite clearly substantial, and I agree with that particular comment. Not just local or regional or national, but of international scale benefits in economic terms, which will be facilitated by the Hif1 scheme. And then similarly, in terms of residential growth, we're talking about many thousands of new homes, both market homes and affordable homes, which again will be facilitated by the Hif scheme. And without, or putting it the other way, without the Hif scheme, those homes just can't come forward, and then there will be catastrophic effects not only in terms of non-provision of that development, but also in terms of each of those districts being thrown into a position where they don't have a 5-year supply, and then we've got ad hoc, sporadic development coming forward, which will be harmful. It won't be plan-led. So massive benefits both in terms of economic development and residential development. And we're talking in terms of at least 15,800-ish homes, but possibly into the 20,000 plus number of homes, many thousands of new jobs, massive economic benefits, as I say. But then there's also a whole range of other benefits, and they're all outlined there in the bullets. Reducing traffic flow and congestion. We've heard a lot about congestion and the effects of congestion. So not just the obvious effects for local residents in terms of getting from A to B, but also impacts for the emergency services. We heard a lot about the aged transport infrastructure. We heard early on in the inquiry about there only being 1 or 2 new bridge crossings over the Thames in the last 100 years. So we're talking about a Victorian or even medieval transport system here. Single lane bridges which are regularly flooded, massive impacts for buses, bus services, congestion growing year on year. So this particular scheme is essential to overcome those issues. And then there's also benefits in terms of active travel. There's a lot of provision for that. You've heard from lots of other witnesses about that. I won't go over that in any detail, but a lot of attention's been paid to cycling, walking. The scheme itself will make bus usage much more attractive, so bus patronage will increase and improve. Resilience of the network will improve as well, obviously, because we've heard a lot about when there are issues in terms of closures of one or more of those bridge crossings, then the whole system goes into chaos. So that those issues will be improved. Severance of communities, ability to get across the River Thames, and I could go on and on and on, but massive benefits. So when you weigh all of this up, and then you come to the summary of harm and benefits, well, you've got some limited harm in relation to landscape and visual. I acknowledge that, and that's inevitable for a scheme of this type and nature in a rural context. But then on the other side of the balance, you've got all of those extremely weighty benefits, which in 6.8.1 I invite the inspector to give very substantial weight to.
Yes, agreed. Thank you for that. Then the final 2 sections of your proof. 7 is a response to representations and objections, and you respond to specific points made in the statements of case and consultation responses from East Hendred Parish Council, the Poets Group and the neighbouring parish councils joint committee. No need to get you to read through that. There are a couple of other things we should just touch on. We know that Mr. Scarf in 2 documents posed questions to you and Mr. Lansborough, so I'm not sure that there's much to be said, but could we look first at INQ 20? And in that document, PDF page 3 has a subheading, Bernard Greep, and there are some questions. Q1, in what way has OCC approached the scheme on the basis of vision-led provision for transport and place investment, aka vision, and validate / decide and provide - manage and monitor, and not predict and provide? Is that really a matter, you know, how OCC is approaching this? Is that a matter for you or Mr. Disley and other witnesses?
That's what I was going to say. I don't know why I was asked this question. It's not a question for me. It's clearly a transport question, which is more appropriate for the transport witness.
then says, question 2, is this assessment in accordance with the RTPI guidance and advice to the Committee on Climate Change included in Daniel Scarf's proof? And by this assessment, I think it's referring to the climate change assessment. Again, is that for you or Mr. Lansborough or others?
Again, that's for Mr. Lansborough, and I think Mr. Lansborough has addressed those questions previously.
And then question 3, in which way, if any, do you take issue with Daniel Scarf's representation of agreed upfront emissions and possible but uncertain offsetting by reduced operational emissions? Again, for you, or was that something that Mr. Lansborough dealt with?
Again, Mr. Lansborough's dealt with this comprehensively.
Do you, question 4, still subscribe to the view that, quote, that the representations and objections based on climate are without merit and do not give any reason to refuse planning permission? Again, is that really a matter for you?
Again, that's a matter for Mr. Lansborough, but what I should say really is it's almost as if I'm being accused here of not giving any weight or attention to climate change. That's not the case, and I'm not trying to pass the buck at all. It's just that Mr. Lansborough is the specialist in climate-related matters. But everything that I do, everything that my company does, Stantec, is rooted in trying to create sustainable development. So we wouldn't have taken on the scheme if we didn't feel that this was a scheme we could support or that I could support. We always take account of those sorts of issues, and we're dealing here with a scheme which is wholly in accordance with the development plan.
And then Q5, which I think just falls away because of your last answer. If they have some merit, what is it? Is there anything you need to say in relation to that?
No.
And then INQ 42, I think we may end up in the same position, but this is headed additional question for Messrs. Lansborough and Grebe, and again it relates to climate change. And Q2, does the CL estimate of the claimed potential savings of carbon emissions arising from the new road take account of, and then increase in traffic from new residential development and behavioural change, and then including things recommended by the AWPGI ICE report, road user charging workspace, etc. Again, is that a matter for you? What the estimate has included?
That's not a matter for me. No, that's a matter for Mr. Lansborough.
And then Q2 Roman 3, the 12 measures and behavioural changes referred to in 2 have the potential to reduce operational carbon. Which of these are adequately addressed by the diagram in the BS note EN 1747-2 that purports to rebut the evidence of Mr. Scarf? Again, is that a matter for you?
No, again, these are detailed matters for Mr. Lansborough and or the transport witnesses.
Fine. Just under response to objections, there is obviously a planning objection from Mr. Roberts of May's properties. My understanding is that that's a matter where there have been a lot of detailed negotiations going on. Have you been directly involved in those negotiations?
No, I haven't.
Madam, you did indicate earlier in the week in relation to this that maybe this is something that Mr. Grebe could pick up, but I suggest it may be better to try and deal with it in the conditions session. Mr. Greep's just not been, because he's been abroad, not been involved in the discussions, if that's acceptable to you.
Yes, my understanding is the matter's still not agreed.
Correct.
And there is, I'm happy to deal with it in the condition session, as long as I understand what so you're hoping to reach an agreement, is my understanding.
It's very much the hope that we can. The issue relates in effect to the relationship between our development and potential development on the Mays property land, and again, I hope I'll be forgiven for putting it in shorthand, but whether the site access points shown on our plans are consistent with what we understand Mays Property would now like to do on their property, and whether or not, and if so, how some other form of site access might be brought forward. As I say, that's a very high level summary, but I hope not unfair.
I'm happy to deal with it in the condition session, and obviously when I look at the modifications schedule, that might help me, or it might not. Looking at your face, it won't. No, it won't.
I don't, unless I'm corrected from Ms. Reynolds, I don't think there is currently a modification on this. I think the issue, and again I'll be corrected if I'm wrong, relates less to compulsory purchase and more to planning, which is why, perfectly properly, Mr. Roberts had produced his evidence as part of the planning inquiry.
Let's pick it up in the condition session, because we're not returning till next week. And if I've got a further question, I can ask a question of you. That probably seems the best way forward.
Absolutely, and as I say, I'm because as far as I'm aware, Mr. Roberts is not here this morning. I'm trying to put it all as neutrally as I can. Thank you.
Okay.
Mr. Greep, then. Finally, your Section 8 is your summary planning balance and conclusions, and I don't think you need to go through it, but a paragraph 8.1.11, you set out your overall conclusions. Is that correct?
That's correct, yeah.
Mr. Greep, is there anything you need to add at this stage?
I don't think so.
Madam, thank you very much. That's our evidence in chief.
Thank you. Mr. Woolley.
Mr. Greep, you came into this case fairly recently, did you not?
Relatively recently, yes.
Yes. After the Planning and Resources Committee of Oxfordshire County Council had resolved to refuse planning permission.
That's right, I was approached initially in August last year.
Indeed. Was that the reason that you were approached?
Well, clearly I couldn't have been approached before. I suppose I could, but actually the officer recommendation was to approve. That didn't happen, so it was called in. Therefore, OCC needed a witness and approached me.
Yes. So the approach was that it was hoped that you would be able to support the application.
I was asked if I could form a view as to whether very special circumstances could be demonstrated for this particular scheme.
Yes.
That was the original approach.
And you tell us at some length in section 1 and 2 of the proof of the steps you took before you were formally instructed.
That's right.
I see you've had more than a quarter of a century's experience of town planning. I imagine that you've given evidence many times at planning inquiries like this, have you not?
Yeah, I've lost count, yeah, probably dozens.
Is it your general practice to set out what you did before you decided that you could act for the applicants?
Generally, yes.
You do?
I do.
As a matter of course?
Matter of course, yeah, to
Yes.
provide, comprehensive account as to how and when it was approached, what the nature of my instruction was, etc., yeah.
Yes. I don't, and I'm not going to suggest that your evidence is anything other than completely honest. I want to make that clear. My case is that it's mistaken. And you acknowledge, don't you, from time to time in the course of your evidence, that the Secretary of State might agree with that.
Sorry, your case is that it's a mistake. What's a mistake?
Well, let's look, for example, at paragraph 5214 on page 50. It's only one of many. Do you have that?
5.2.14.
5214. I acknowledge that the Secretary of State might disagree that the scheme preserves the openness of the green belt, and take the view that the scheme will result in some permanent and unavoidable harm to the openness of the green belt, and or that the development will conflict to a degree with some of the 5 purposes of including land within the green belt. That, as you probably know, is the case that my clients are putting forward. Did you know that?
That your client is putting forward... Sorry, could you repeat that, please?
Did I not make myself clear?
No, I don't think
I'm
you did.
sorry. My clients do argue that the scheme will result in permanent and unavoidable harm to the openness of the green belt. Do you understand that?
I understand that, yeah.
They also argue that the development will conflict to a degree with some of the 5 purposes of including land within the green belt. Do you understand that?
I understand that case,
Yes.
yes.
And you acknowledge, don't you, that it is at least possible that the Secretary of State will come to the same view?
It's entirely possible, yeah.
Yes. And that's what you called hedging your bets?
That's not what I called hedging my bets. That's what one of your witnesses called hedging my bets.
I see. While we're looking at this late part of the proof, one point that caused me some surprise, and I'd like your help with. Would you turn to paragraph 6.8.1 on page 65?
Okay.
The first bullet point, I give substantial weight to the harm to the green belt which has been described in this section of my proof. The other harmful effects are small in number and relatively modest in scale and effect, such as I give them only moderate weight in the determination of the planning application. I say that's startling because, correct me if I'm wrong, I don't find anything in section 8, which identifies harm to the green belt, do I?
Well, what I'm talking there about is this is in relation to the very special circumstances.
Indeed.
In the event that the Inspector and or the Secretary of State decide that it's not a 155C scheme. So therefore I've turned to very special circumstances. As you know, the starting position when you consider very special circumstances is that the scheme is deemed to be inappropriate development in the Greenbelt, and the starting position against that context is that substantial weight should be given to the fact that the scheme is in the Greenbelt in the first place. So that's why I've given substantial weight to the harmful effect of it being in the Greenbelt in the first place.
Well, let's be clear. Do you or do you not accept that there is harm to the green belt?
No, my fundamental position is that this is a scheme that should be supported and is very clearly capable of support under 155C.
But because it does not cause material harm to the green belt?
Or because it's local transport infrastructure.
Then why, this may be merely a verbal argument, but why do you say in 681 that you give substantial weight to the harm to the green belt? I find it difficult to reconcile the two propositions.
I've just answered that, madam. It's because this is the very special circumstances part of the proof where, again, if it wasn't clear, I'll repeat the point. My position is that this scheme is capable of support under 155C as a local transport infrastructure scheme if the inspector and or the Secretary of State form a different view and therefore decide that it's necessary to consider whether VSCs exist. That's why I've then gone on to consider exactly that point. And the starting position in that context is that development is deemed to be inappropriate and therefore substantial weight should be given to development in the Greenbelt. So I have to give substantial weight to it in that context.
So Mr. Group, your starting position is that for the purposes of paragraph 155C, that the impacts on the openness of the Greenbelt are acceptable and don't give rise to harm, but if it doesn't fall within there, that you accept there would be an impact on openness.
Well, I accept that there's an impact on openness, but there has to be an impact on openness.
And it's tolerable within.
And it's tolerable, yeah.
Within there, but if it doesn't fall within 155, you acknowledge that it's something that needs to be weighed in the balance.
Exactly.
Thank you.
And the very special circumstances are, among other things, the housing and employment objectives, which we find in the development plans, aren't they?
We do, yeah.
And if the Secretary of State were to conclude that those objectives could be achieved without a new road, do you follow the assumption?
I follow the assumption, but
yes.
that's, if I may say so, that's...
May I finish?
Okay.
And if the Secretary of State concluded that, then the special circumstances would evaporate, wouldn't they?
Well, in that highly unlikely event, yes, but it's untenable to suggest that many thousands of new homes, many thousands of new jobs, etc., could be achieved without the road.
Similarly, I suggest, if the Secretary of State were to conclude that alternative means of transport, other than a new road, needed to be investigated, then equally these very special circumstances would cease to exist, wouldn't they?
Well, alternatives have been considered. We heard very extensively from Mr. Wisdom about the alternatives. A very extensive optioneering exercise was undertaken over many years. Consultation was undertaken, in addition to which the Hif scheme is embedded in adopted local plans, all of which have been tested and adopted after rigorous examination. The scheme is embedded in the development plan. It's not as if some fictitious alternative could come forward. The scheme is in the development plan. That's my position.
Help me, I'm trying to find the passage at the beginning of the evidence. I think it's in section 1.2, where you tell us that you were formally instructed by the County Council.
That's right. Well, it's 1.2.7.
Thank you. What were the terms of those instructions?
Okay, so what happened is I was approached in August, as I say, August 2023, and between August 2023 and October 2023, I went through the background documents in some detail to form the view as to whether in my view, very special circumstances existed for this particular scheme. Now, at that point in time, I could have done various things. I could have concluded that either, in my view, VSCs couldn't be demonstrated, or that there were gaps in the evidence which meant that additional evidence needed to be collated in order to present a VSC case, or I could have concluded actually that I wasn't happy to take on the case because, in my view, the harmful effects outweighed any benefits. The view that I came to early in October was that actually VSCs, very special circumstances, could be demonstrated for the scheme. I then presented a note and explained that to OCC, and then they instructed me to present evidence on that basis.
Were your instructions in writing or oral?
In writing.
Would you object to my seeing a copy of them?
There is
Well,
no
Is-
proper
is it
basis for
sorry.
that, as Mr. Woolley well knows.
I wouldn't expect the need to see that, Mr. Woolley. What would be the reason?
It's for the sake of completeness rather than anything else.
I think what we're looking at is the evidence that Mr. Group is putting
Very
before
well,
the
I'll move on.
inquiry, and I don't think his instructions need to be put to the inquiry.
Go to page 15, 1-5, please. Paragraph 3.3.13. You conclude, you tell us, that the scheme falls within paragraph 155C, such as it is not inappropriate development in the green belt, and this means that policy strategic 6 of the SOLP is not breached. Were you here yesterday when the witnesses, when Mrs. Baumann gave evidence?
Oh, I couldn't make it, no, but I've caught up afterwards and spoken to colleagues who did observe.
In paragraph 3.3.15, you quote from the report, one of many quotations, and the third paragraph begins, the LTCP, which does not form part of the development plan, but is a material planning consideration, sets a clear vision to deliver a net zero transport and travel system. Do you share the view that the LTCP is a material planning consideration?
It's a material planning consideration, yeah.
And as I read the words delivering a net zero transport and travel system, that means one with no carbon emissions, doesn't it?
Well, again, I think that's a question that is more properly directed at Mr. Lansborough, and I believe he's already addressed that in some detail.
You have no view about that?
I'm not a qualified climate change specialist, and again, Mr. Lansborough has dealt with that extensively.
And in paragraph 3.3.16, you set out the report's establishment of the objectives of the scheme, one of which is reducing congestion. Have you concerned yourself at all whether that reduction will be permanent or temporary?
Well, again, I'm being asked questions here about climate change and transport, which have already been dealt with by the relevant specialists.
So you've not considered it?
Well, I've considered the evidence that's been presented to me by those relevant experts, and I've taken on board and accepted that evidence.
(3.3.18) on page 16. You consider that the scheme is not wholly compliant with the relevant development plan policies in respect of landscape and visual impact for the reasons that you explain below. You're not alone in that view, are you? There are a number of the District Council witnesses agree with you.
Well, and I've accepted that a scheme in this particular context inevitably will have some degree of impact on landscape and visual effect.
Yes, we'll have to come back to that, but I'm grateful for the answer. Go to 3.3.23, please. It's on page 18. About 3/4 of the way down that paragraph, you say, and I think this is your view, isn't it? Not the officers in this paragraph.
Which particular...
3.3.23.
Yeah, 3.3.23. Which particular part is it you draw my attention to?
Is your comment, isn't it?
Yeah, this is my comment,
Yeah, yes.
having considered the committee
And about
report.
3/4 of the way down
Yeah.
it will not be possible to provide a highway scheme in a rural context without some significant adverse landscape and visual effects. And as I concluded above in respect of the principle of development, the scheme comprises strategic infrastructure which is explicitly identified in the development plan as necessary and so on. Would you agree that one could go further and say also that it's not possible to provide a highway scheme without some significant effects on rural tranquility?
Well, again, I think that's a question that's better directed at Miss Ash, and I think it probably has already been directed to Miss Ash. I've already accepted, though, that in relation to that particular part of the paragraph you draw my attention to, that yes, it is not possible to provide a highway scheme in a context such as this, a rural context, without some adverse impact in relation to landscape and visual. Although, as I also clarified earlier on, Miss Ash, in her examination, specified that that degree of impact is localised.
So when you say that, the landscape and visual impacts...
Landscape and visual impact, madam, yes.
Right. And you don't have a view on tranquility, is that what you're saying?
I think it's a question that's better directed to the landscape specialist. I don't profess to be a landscape specialist.
That's what I was going to come to next. There's a side heading on this page 18 of design and layout. Do you claim expertise in that area?
No.
Turn over to page 19, air quality. You don't claim expertise in that field either, do you?
No, nor in noise, etc.
You anticipated my question. Nor in noise, nor in flooding.
Nor in any of those technical disciplines,
Right.
no.
And so that takes us through, doesn't it, to, well, let's go to page 27. Do you claim expertise in cultural heritage?
No.
So that really takes us through, doesn't it, to page 31, where you have the side heading, call in matter C, where you do claim expertise.
Call in matter C is the extent to which the proposed development is consistent with the development plan for the area
Yes.
when read as a whole. So, in that regard, yes, I do feel able to comment.
And that's where you do claim
Well,
expertise, isn't it?
Yeah. Yeah, I'm a planning consultant. I'm not an acoustician or climate specialist, etc.
When we come to the draft South Oxfordshire Joint Local Plan, South Oxfordshire and Vale Joint Local Plan, which you cover on page 32, the third bullet point in 3.4.7, I believe introduces something that we've not heard before at this inquiry. Do you know when these councils declared a climate emergency?
I don't know the specific date, no.
You don't?
But what I did, sorry, just to provide a supplementary point, when I caught up with colleagues yesterday, following, I think it was Miss Bauman's cross-examination, I was told that her view is that the fact that there is a climate emergency doesn't mean that this scheme should be refused. It's important, of course it is, but it doesn't mean the scheme should be refused.
And as they say lower down in this same paragraph, to achieve this, that's net zero carbon, we'll need to ensure developments within the districts produce as few carbon emissions as possible. Do you agree with that aspiration?
I think that's a perfectly reasonable aspiration.
Then you deal later in the proof at section 4.3 with something like 12 planning decisions, appeals. Which of them are in Oxfordshire? I could only spot one, which is Mappleborough Green. Am I right?
Well, short answer is I don't know, but I would say with respect that's irrelevant. These are appeal decisions which have grappled with the matter of local transport infrastructure, so they are relevant, and particularly the Hingston decision, which, if I'm not mistaken, is a decision in relation to a scheme in South Cambridgeshire, so not Oxfordshire, but South Cambridgeshire, which, as I outlined earlier on, is a Secretary of State decision. So I would say highly pertinent to this particular case, even though it's not in relation to a scheme in Oxfordshire.
Yes. Well, I understand that, but I just want to get the facts. Other than the possible Mappleborough Green decision.
Madam, I should just
None
make
of
clear, I
them.
think Mappleford Green, that Henley is not Henley on Thames. I suspect it may be Henley in Arden. That's a Birmingham postcode.
Ah, I defer to
can see
I
it.
defer to the
Well,
geographical
Midlands
knowledge
somewhere.
of opposite.
Yeah.
Right. Well, then it looks as if none of them are in Oxfordshire, doesn't it?
That might well be the case.
Yes. And I want to suggest that this question of local or strategic is largely a semantic, verbal distinction. Would you agree?
Well, I think, as I've outlined on page 44, that one of those decisions talks about the term local should be given meaning, and then there's an explanation as to what's meant by that. I would say this is the epitome of a local transport infrastructure scheme. It's local to South Oxfordshire and the Vale of White Horse. And I haven't heard anybody at the inquiry depart from that view.
Well, the question was, do you agree that it's largely a verbal matter, a matter of semantics rather than of reality?
It's a matter of considering whether it's a local transport scheme or not. So
No, whether it's local or strategic.
local or street? Well, it's local. It's local to Oxford,
Well,
South
so
Oxford and Vale of White Horse.
So you say.
Well, that's a matter of fact.
Let's look at the decisions in 4.3.11 and 4.3.12. I don't propose to read them, but they both related to motorway service areas, didn't they?
4.311, that one did, yeah, motorway service area.
And likewise, for the Cobham
Cobham, yeah.
is also a motorway service area.
Yeah.
In one, the decision was that the proposal was local, and then the other that it wasn't, that it was strategic.
Yeah, so 4.3.12, this is the Cobham motorway service
Yes.
station, yeah.
And
so,
the reasons are given.
yeah, again, that's the one that was described as local
Yes.
transport infrastructure, which served a local purpose, a local public purpose.
So was that decision for the whole of the services, or was it for? It was an additional HGV parking area. Okay.
Move on to page 45, please. 4.3.23. I want to suggest that, again, the dispute as to whether or not the openness of the green belt will be preserved or not is largely verbal. And that's what the next few questions are going to be directed at. You see at the end of the first paragraph of 4.3.23, against that background, the same paragraph of the officer's report of July last year then stated, it is difficult to conclude other than the road would fail to preserve openness. And you go on to say, I do not agree that if the impact on certain views is significantly adverse, it automatically follows that the scheme would fail to preserve openness. Preserve could be interpreted, couldn't it, as meaning have no effect whatever on.
That could be one.
That's not the view that you take, is it?
That's not the view I take.
But it seems to be the view that the officers took.
That's the view that the officers seem to have taken, yes, judging by that extract.
And it's for that reason, and that reason only, I suggest, that you feel able to say in 4.3.25, my professional opinion is that the scheme preserves the openness of the green belt. It's largely, isn't it, because in your view, it doesn't significantly affect it.
That's right. Yeah, so the wording of 155C, if we turn to that, is provided such schemes preserve its openness. It doesn't say fully preserve its openness. And the mere fact that 155C exists, as I've explained, by definition means that a degree of harm to openness is tolerable. So therefore it becomes a matter for the decision maker as to whether that degree of harm on openness is acceptable or tolerable.
And another dispute which I'm tempted to suggest is really not much more than verbal, arises out of the third bullet point in paragraph 4.3.27 on page 46. Thus, you say, the scheme's impacts on the two conservation areas have been expertly assessed as slight adverse at worst. In the case of Clipton and Hampton, the overall effect, relying on the content of Dr. Scott's heritage technical note, could be described as positive. So what you're saying there is that a road carrying however many thousands of vehicles a day it is, close to a conservation area, has a positive effect upon it. That's right, isn't it?
No, I'm relying on the evidence of Dr. Scott.
Yes.
And it's the preceding paragraphs, which I won't read out, but actually I was just making the point that it could be construed that the impact on that particular conservation area, yes, is positive.
And you make the same point, don't you, in paragraph 5.3.2 later on?
That's right.
Yes.
And the reasons for that are, as I say, outlined in the preceding paragraphs, which I won't go through in detail.
Go on to page 47, please. I think 4.3.29 really emphasises the matters we've just been discussing, doesn't it? I acknowledge, you say, that paragraph 155C is not completely clear as to which extent to which the openness of the green belt must be preserved, while still enabling the physical construction of local transport infrastructure schemes within the green belt. That's the same point that we've been discussing, isn't it?
It's the same point, yes. There's no definitive position. There's no. It's not a calculation that can be done. It's a matter of judgment for the decision maker.
But it really comes down to a matter of judgment.
It does.
Page 49, Greenbelt purposes, paragraph 5.2.9. Area 6, the South Oxfordshire District Council assessed, makes no contribution to the first purpose of the Green Belt, that is, preventing sprawl, a low contribution to the second purpose, prevention of merging towns, and high contributions to the third and fourth, that is protecting the countryside and the special character of historic grounds. Do you agree or disagree with that?
Well, it's a factual account of what's in that study, so I don't disagree with it.
I think the question was, did you agree with that view?
Oh, okay, so
It was.
scheme extent falls within Broad Area 6 as defined in Oxford, so that's a fact, which found that Broad Area 6 makes no contribution to the first purpose, low contribution to the second, and high contributions to the third and fourth purposes.
Yes. And I'm asking, do you agree?
I'd have to get the report out. I haven't got that in front of me. Happy to go through the report if that would be helpful, but
Yes.
I haven't got it in front of me, so I can't actually answer that question now, I don't think.
I think the question is, do you agree with the assessment as to that level of harm with the purposes?
Yeah, I think the point that's being made is specifically in relation to the third purpose, encroachment into the countryside. But I think what I'd say there is, in the context of 155C, I consider this to be an acceptable scheme. So whether a high-level green belt study comes to a view in relation to a broad area or not is a different point. When I'm considering this particular scheme in 155C, my conclusion is it should be accepted, and therefore there isn't any conflict with the third purpose.
But this is, of course, is about paragraph 143, isn't it? Not 155.
So this is 143, yeah. So
Yeah.
they're the 5 purposes of the green belt.
And I asked the same question in respect of broad area 8. Do you agree or disagree that it makes a high contribution to the purpose of as safeguarding the countryside from encroachment?
Well, the overall broad area might well do. But what I'd add to that is it's important to consider that the scheme is safeguarded in the adopted development plan. So even if that broad area does make a strong contribution to the third purpose, that doesn't detract from the fact that we do have a safeguarded route.
I hope you'll forgive me if I don't cross-examine you about your responses to the representation and objections. We've covered all these already in the inquiry. I don't mean any discourtesy, and I'd like you to understand that.
That's fine. I acknowledge that.
Thank you. Those are my questions, Madam.
Thank you. So, paragraph 6.415. That's where you're listing the benefits of the scheme. We've looked at lots of these benefits previously, but you do have your third bullet point. You're talking about maybe creating low traffic neighbourhoods, that this would be, you're listing these as significant benefits, the ability to implement traffic calming measures and 20-mile-per-hour zones in the villages. Is that an intention of the scheme to do that?
Might not be an explicit intention of the scheme, but I think it would be something that would potentially happen if the scheme is implemented.
And would it be possible, in the absence of the scheme, would it not still be possible to implement those measures?
It would be more difficult because of the existing problems which have been highlighted by various witnesses. And really the same question on the next bullet point down, the fourth bullet point, where you're looking at HGVs and road classifications. Are they dependent on the delivery of the road? Pretty much, I would say yes. I've heard about the major problems that already exist in relation to traffic movements generally, but also HGV movements. And if Hif1 was approved and implemented, then those movements would significantly improve.
Thank you. In your proof at paragraph 3.340, it's quoting from the committee report in terms of the impacts on biodiversity. And it says that it's accepted that some impacts can be avoided or reduced or mitigated, and that biodiversity net gain could be achieved. So we've heard about the biodiversity net gain that can be delivered, including offsetting. In terms of the remaining impacts there on biodiversity, what do you consider could be avoided?
Madam, I'm not an ecologist. I'm not able, I don't think, to answer authoritatively on particular ecological constraints, I'm afraid.
Okay. But you've concluded that the scheme is compliant with the development plan. So have you read the evidence?
I've read all the evidence, yeah, from the relevant experts.
So there are proposals to relocate some species, both of which are critically endangered, and you think that having read the evidence, you're still convinced that
yeah, I've accepted the
complies.
evidence. Yeah, sorry, madam, I've accepted the evidence from the relevant experts who assure the team that everything will be acceptable in those regards, yeah.
Thank you. So I've appended to your proof is the evidence of Dr. Gillian Scott in terms of heritage. And I can follow that, and that's address matters that I said I needed evidence on. Within the assessment's largely within the scheme area and the study area as defined. We've heard that the scheme would be likely to reduce traffic using the existing listed bridges, the Cullen Bridge, and I know I've been corrected on the name. I think one's called the Shillingford Bridge, but I do have a note of those ones. So Do you think there'll be any impact, positive or negative, on those bridges in heritage terms?
Again, I'm not a heritage expert, but just as a layperson, I would imagine that there would be a positive impact.
Do you? So, as I understand it, you're summarising the views from the other experts, and you're not in a position to comment on any of the
That's right.
evidence there. Okay. Thank you then. That's my
Okay. Thank you, madam.
questions for you. Yes, Mr. Scarf. Well, again, you can't make a statement, but if you've got a question on the evidence. Mm-hmm.
There's been many opportunities to contest it, and I have listened very carefully. I haven't heard it contested. The reason that's just so important is the Oxford Street Marks and Spencer decision, which all the planning laws will go around, where the Secretary of State failed to persuade the court that he's adequately dealt with upfront carbon. So the Secretary of State knows the difference between upfront carbon and operational carbon. When you conclude this inquiry, your decision is more bomb-proof, court-proof than the Secretary of State's was in that case, and did hinge as one of the material factors upfront carbon. So that's why I've appeared here and tried to persuade you that upfront carbon is different and significant. And I say Mr. Humphries can respond to that now or on Tuesday.
Thank you, Mr. Scarf. Mr.
Madam,
Humphries.
I think the only thing I'll say is as you know, the environmental statement does include a calculation of embedded carbon. I can't remember the figure, but in the environmental statement, it's put in relation to the budgets. It's put against the fourth carbon budget because that's the relevant period during which that carbon would be in effect created. Not aware that there's any challenge to that from any expert evidence, and we rely on our evidence both for what Mr. Scarf's called upfront, i.e. embedded carbon, and also for operational carbon.
Thank you. So, Mr. Humphries, do you want to re-examine?
Yes, madam. Mr. Greep, just going back to early in the period when you were asked questions, and you were asked about the fact that you had been instructed to give evidence. You had already recorded in your evidence that obviously the officers had recommended, planning officers at the council had recommended approval, but members had rejected, and you'll have heard the County Council's local planning authority make it clear that both as applicant and planning authority things have been at arm's length. Was it therefore even possible for the County Council as applicant to call a County Council planning officer to give evidence?
No, actually thinking about it, no, because there was a recommendation to approve the application that, on the night it didn't go that way, and then it ultimately got called in, so it would have been difficult.
Yes, and it was put to you, therefore, that you were instructed after after the council resolved to refuse. Is there anything, therefore, in that context, surprising in that?
Not at all.
Mr. Humphreys, I do apologise. I did have some further.
Oh, I do apologise,
no,
madam.
No, that was me. I'd forgotten that.
I thought,
Sorry.
I hope I haven't
I
jumped
just think
in.
it's probably better if I put them before you, so you could re-examine it once. So the area I wanted to look at actually was design, and particularly in terms of the bridges, and the framework, paragraph section 12 and paragraph 135 onwards looks at design, provides guidance of design, and certainly the new framework provides more of an emphasis on beauty and design than previously. And I've wondered to what extent you feel that this scheme complies with that guidance in the bridge. So I've heard from Mr. Blanchard and Mr. Chan on in terms of the functional need for the design, but in terms of the aesthetics, and they're also picked up in I think the national, I must get the name wrong, National Network's National Policy Statement that also discusses the need for aesthetic design considerations, and to what extent has that been considered?
It's certainly been considered. I mean, again, I'm not a design expert, so I haven't gone into detail myself. I've listened to the discussions carefully, and I think yesterday a couple of the officers said actually in their view, Madam, the Science Bridge could possibly have been improved, but notwithstanding that point, that wasn't a reason for refusal in their view. And then I also heard that the bridge over the Thames actually is quite a subdued design, which one of the officers thought was entirely appropriate given the context, and I'd agree.
But what I've actually asked is to what extent was the aesthetics of the design taken into account? You say it has been considered. Do you know where I find that?
Offhand, I don't know, unfortunately. I know Mr. Chan or Mr. Blanchard, I think, would be better placed.
No, they discuss the functional design, not the aesthetics.
Yeah. Again, I haven't considered it in my evidence. It's not my remit, Madam, to consider the particular design. I don't know if others could take it to that.
So that was the area, thank you.
Okay.
Mr. Humphreys, if you want to continue.
Madam, thank you for that. It was then said to you that by, on the one hand, saying that this was not inappropriate development, but on the other hand, going on to consider very special circumstances, that you were hedging your bets. Is that an appropriate characterisation of your position?
Again, as I said in response to Mr. Woolley, that's not a phrase I used. That was a phrase that came from one of his particular witnesses. I wouldn't use that phrase, hedging my bets. The reason I've done it that way is for completeness and comprehensiveness, because as I hopefully made clear, my primary position is that the scheme could and should be supported under 155C as a local transport infrastructure scheme. But I accept that the inspector and or the Secretary of State might take a different view. Now, if that was the case, And if I hadn't addressed very special circumstances, then the inspector and the Secretary of State would be left in the position where the applicant's planning witness hadn't commented on whether VSCs were capable of existing or not. That's why I've addressed it in that way.
And we know that the Rule 6 parties, including poets, oppose the scheme and say that planning permission should be refused, and yet Mr. Tamplin has commented on conditions. Would it be fair to characterise Mr. Tamplin as hedging his bets?
Well, to use the opponent's phraseology, then yes.
Next point. You were asked about your paragraph 6.8.1. And very special circumstances, and the first bullet point, I give substantial weight to the harm to the green belt, and you explained that that's obviously in the context of policy. Can we go to the MPPF? So that's document CDG.20. And paragraph 152 and 153, both on PDF page 44.
Yeah.
And 152 says inappropriate development is by definition harmful to the greenbelt and should not be approved except in very special circumstances. But then this in 153, when considering any planning application, local planning authorities should ensure that substantial weight is given to any harm to the greenbelt. Now, is that the context within which you say at the first bullet point at your paragraph 6.8.1, I give substantial weight to the harm to the greenbelt, in the section where you have assumed that this is inappropriate development?
Yeah, that's entirely right, and you've categorised it probably better than I did in my answer, but that's entirely right because of what 155 of the MPPF says. Starting position is that any inappropriate development in the green belt is automatically ascribed substantial weight. Definitional substantial harm in that regard.
And later you were being asked about alternatives, and you made the point that this is a scheme that exists in the local plans, the two local plans, and Ms. Bowerman yesterday made the point, I think Mr. Butler made the point as well, about the importance of the plan-led approach to planning. To what extent should the inspector place weight on the importance of the plan-led approach in a scheme of this sort?
Well, I would invite the inspector and the Secretary of State to place substantial weight because we operate in a plan-led system, and what we have here is a situation where some development sites have been removed from the local plans, so exceptional circumstances have already been demonstrated sufficient to warrant the removal of development sites. We also have land safeguarded in each local plan, which, as I say, has been through the rigorous process and then has been tested and adopted. So it would be bizarre, in my view, for that infrastructure which is needed to unlock and facilitate those schemes which have already been taken out of the green belt not to come forward.
And you were then asked a series of questions about the circumstances in which you having been instructed, came to your conclusion on paragraph 155C, and you were asked for your written instructions. Can I just get you to clarify, were you at any time either encouraged or indeed discouraged by anyone at Oxfordshire County Council or anyone acting for or representing Oxfordshire County Council to form a particular view in relation to paragraph 155C?
Absolutely not. That was my own view that I formed independently. Nobody coerced me, nobody instructed me, nobody asked me. That was my own independent view.
And at your paragraph 1.3.12, you set out your duty to the inquiry. Have you complied with that duty?
I believe I have, yes.
And you were then asked at a later point whether you were an expert in the various disciplines which are dealt with in your section 3.3, other than the planning aspects of those issues. Just invite you to go to your paragraph 1.3.8 and 1.3.10. 1.3.8, you say my proof of evidence should be read in conjunction with other separate but interrelated proofs of evidence, technical notes and so on submitted, and they are listed. And then 1.3.10, in arriving at my overall conclusions, I have relied in part on the professional views of the aforementioned witnesses in their own proofs of evidence and technical notes. And do you therefore, in those sections of 3.3, rely on that other evidence as set out in the written proofs?
Yes, I do. By definition, I'm a planning consultant, and so I'm not a specialist in any of those technical areas, and therefore I have to rely on the expert evidence of those witnesses. And
at a later point, you were asked some questions in relation to, I think, your paragraph 5.2.9 on the Oxford Greenbelt Study and Broad Area 8, and you made the point that the broad area is a, as the name suggests, a broad area and might have a strong connection with Purpose C, Greenbelt Purpose C. Just because a broad area may have a role in relation to one of the purposes, does that determine whether a particular development harms that purpose?
No, in summary it doesn't, and I see this all the time actually. As you say, by the name, as the name suggests, by definition, broad covers quite a large area. And quite often, when I'm confronted with schemes or proposals, you have a situation where the broad area is quite extensive, but the particular scheme actually wouldn't harm the Greenbelt. And the point I was trying to make there is, we have a situation here where the scheme, the Hif scheme, is safeguarded in the development plan. So even if the overall broad area does make a contribution to a particular purpose, well, so be it. We still have a development plan-led system which makes provision for a scheme in that location, even against that background.
Mr. Greep, thank you very much.
Thank you.
That's, in a sense, not the last of our planning witnesses, because the planning inquiry is technically still open and we have our witnesses who will be called next week, but that's the last of our evidence, obviously, in this part of the overall inquiries. Thank you.
Thank you for that. It's 12:15. My thought is if we took a half an hour's break and then returned and dealt with the conditions at that point. Have you got an alternative?
Could we, we're still discussing some things with other parties.
Mm-hmm.
Could we make it 45 minutes?
Absolutely. I was trying to...
No, madam, in other circumstances, believe me, I would be all for a half-hour break, but I'm just conscious that not I, but Ms Reynolds and others are furiously sending emails back and forth, and I'm to various parties, and I'm just keen that that we try and get as settle a position as we can.
No, I think that would probably save time.
Thank you.
So we'll return at 1 o'clock. Okay, thank you.
Perhaps I should say, before you go, I'm going to hand over to Mr. Tamplin at 1 o'clock. He knows far more about conditions than I do.
Thank you, Mr. Woolley. So you be leaving? Or?
No,
you're still here.
I wouldn't miss it for a world.
Thank you. Sorry, do you need an additional seat? No? Right. You... Right. Okay, so it's 1 o'clock and I'd like to go through the conditions. As everybody's aware, poets have made some comments on the principle of conditions. I think it might be more useful to run through the actual conditions first and then pick up on those comments. So, do you have a view on that, Mr. Templin?
I'm sorry to be awkward, but I would prefer it if we could do it the other way around, please.
Okay, I don't have a problem with that.
Then I shall answer Mr. Humphrey's prayers, and I shall depart from the forum.
Right. Okay. You do understand, I'm sure, that I still need to run through, regardless of your comments. I've got to go through the conditions on that basis. So, so your comments are document Q4.
Yes.
So obviously don't read them, they've been circulated, but if you want to make your main points from them, and then I'll give the council and the other Rule 6 parties an opportunity to respond.
Thank you. I think I can probably summarise everything from what I've said on the first page of what is in, is it Q06? With due respect, I see no purpose in using the pro forma method of dealing with this matter. This is in respect of my views, because my comments are so fundamental to what has been put forward as agreed conditions by the County Council, that the simplest and clearest way is via this list of comments. It explains why so many of the suggested conditions fail one or more tests of the NPPF and NPPG for reasons stated, and therefore should not be accepted by the Inspector or the Secretary of State. I'd like to just slightly correct that last part of the sentence, because obviously I recognise, Madam, that you are under a duty to report all views to the Secretary of State, and that's what you'll do, of course. Because the underlying purpose of imposing conditions on any application for planning permission is to make acceptable what is presently unacceptable in a submitted application. The unacceptable, in my view, of 30 of the 37 suggested conditions in this case means that what remains would be an incomplete and unacceptable application. And in that respect, I would refer to the NPPG as, well, I printed this out yesterday evening, but it's there available online at any moment to see.
So do you have the PPG reference?
Yes, I do. It's paragraph 001, 001, reference ID 21A-001-201-40306.
Thank you.
And it says at the beginning, if I can just read a little part of it, when used properly, conditions can enhance the quality of development and enable development to proceed where it would otherwise have been necessary to refuse planning permission by mitigating the adverse effects. The objectives of planning are best served when the power to attach conditions to a permission is exercised in a way that's clearly seen to be fair, reasonable and practicable. It is important to ensure that conditions are tailored to tackle specific problems rather than standardised or used to impose broad, unnecessary controls. if I can just briefly return to what I wanted to say from my note. Paragraph 2, the acceptability of a suggested planning condition is a matter of law and judgment, the latter being guided by policy and guidance. And then I set out the legal powers in a case to be determined by the Secretary of State. Present policy and guidance are contained in the NPPF, paragraph 55, and the NPPG, use of planning conditions. I will only say that my comments were made at the time this was written in January 24, that's 2024 this year.
Yes, it was late last year, early this year.
Yes, indeed. So they were on the state of these conditions, and they may be that there have been some changes, although I've not been able to identify them in the time that I had available to me. I will suffice it to say that I accept and agree with some of the comments that you've made, Madam, on parts of some of these and some of these conditions, but that I still have serious reservations about the number of conditions and the format, particularly of the pre-commencement conditions. And I only want to say two other things. The first thing is that I would suggest, and this is, I know, a new suggested condition, but I'm sorry, but I've not had the opportunity to do this before. But I do believe that it will be reasonable and logical, and it will comply with the 6 tests of conditions for a condition requiring a joint liaison committee to be made in respect of the construction of this development, which I think we have heard is likely to take 2 years or more if it is approved, because that's a reasonable period, and beyond it, up to 5 years, when several of the conditions are still in the, if you like, implementation stage. And it's important for local people to be involved in some way in the process so that they can express concerns to such a liaison committee, and that the reports of that liaison committee are sent to the local planning authority so that it can see the voice of the community in relation to this. I think that's extremely important. I have drafted something, but I'm afraid I'm not in a position to actually print it or send copies round of it. But I will, if you wish me to print and send it to people, I'm quite happy to put this in before the end of the inquiry.
Okay. I think it would be helpful if you would circulate it. I don't need you to print it, but obviously copy all the parties in.
Yes.
And before, when you say before the end of the inquiry, before
the end of this inquiry,
right,
the planning inquiry,
because
yes.
you may have been away, but we'll formally close
Indeed.
later.
No,
so that
I
will be some
understand.
point next week.
23rd of April or whenever it happens to be.
No,
Yes,
that's fine.
yes, indeed.
That will give people a chance to
Of
comment
course.
on it.
I shall try and do it this weekend. I'll make sure
that
I
would
do.
be appreciated.
Thank you very much.
When you say joint liaison committee, have you got, what's your intention? Parish councils? Or?
Yes, the local parish councils along the route of the development should be represented on that liaison committee, as of course would the the applicant authority, because it is on their land and it's their development, so clearly they've got to be there.
Okay.
And I just wanted to say that the reason I'm raising this is because my experience in the field of minerals and aggregates, particularly of open cast coal extraction, is that joint liaison committees are a feature of what happens and are set up, or were set up, because there aren't many, if any, open cast coal sites left in this country, between the operator, which was either British Coal or its predecessor, and the local community to precisely do this. So I think that although this is a, if you like, not an ongoing but a fixed development, it has a long construction time frame, and it has got many features such as planting, where monitoring and so on is extremely important. And it's important, as I understand it, to the County Council's case.
Thank you.
Thank you.
So what I propose in terms of that additional condition is if Mr Templin submits it and maybe comment on it before we hear closing submissions, or if we need to do something further. But aside from that, do you have any comments on it at the moment, Mr Humphreys?
On that condition, yes. I mean, I'm not sure what the role of the liaison committee is. What is it liaising about? It is true that very often outside the context of planning conditions, contractors will set up contact with local groups just to inform them when particular works are taking place, that sort of thing. But it's fairly unusual in the context of a planning permission to impose such a thing. So we will obviously look at whatever is proposed, but normally the local planning authority are the people who represent local communities.
Going to come to the planning authority, but yeah, thank you. Sorry, you, Mr Perry.
Thank you, Madam. Yes, we do put conditions along the lines of what I think Mr Tamplin is suggesting.
You need
Sorry.
to...
Is that better? Sorry.
That's much better.
Yes. Obviously, we mainly deal with minerals and waste at the County Council, and we do put conditions, I think, along the lines of what Mr Tamplin has suggested on some of the mineral permissions, to have a liaison meeting, normally with terms of reference to be established, obviously, at the start, and then inviting, representatives of the local community.
I'm sorry, can you move they're very directional.
Right. Is that better?
Yeah, I can hear you, but I'm not sure everybody...
Can you hear me?
That.
Okay. So I'm agreeing with Mr Tamplin, which hopefully is a good thing. And I would say our view as local planning authority would be we'd see no reason why you can't put that on, or the Secretary of State couldn't attach such a condition if he's minded to approve this application, because we do that on minerals permissions.
Thank you. Do either of the district authorities have a view on it? Mr Butler?
I think we'd like to read the condition before making any comment. Thank you.
I think that's probably correct. We need to see what's in writing, but does anybody else have anything to say on that? No? So thank you for that, Mr Templin. Mr Humphreys, do you want to respond to, well, not just yourself, but Mr Templin's overall comments, aside from that condition?
Yes, Madam, in very general terms, there seem to be two types of point made. Clearly there's lots and lots of detail, but one type of point which you can see made early on is that in some way the conditions imply that the environmental information available to you and the Secretary of State as decision maker is in some way inadequate, and we, we do completely reject that, so that you can see, for example, in paragraph 4, I choose it just because it's early on, it said that suggested condition 25 requires an assessment of carbon emissions to support carbon reduction and proposals for continued improvement. This all but admits that no assessment of carbon emissions has been made to date. Well, that's clearly wrong. You've had a lot of evidence on this, and it then goes on talking about the decision in Holohan to say this contravenes regulation 4.2 and 18.3 and renders the ES invalid. Well, that's, again, just completely wrong. So there are a number of points of that general type that seem to imply that environmental information is not available. And indeed, one of the points, or one of the series of comments that you've made in your own comments is, but isn't this available already in plans or documents or other things, which sort of rather reinforces the point that actually it is there. The second type of point overall, and again, you can see this from paragraph 7 onwards, it says some 24 of the suggested conditions are also pre-commencement conditions. And quite often later, all that's actually said about a condition is, oh, well, it's a pre-commencement condition and therefore in some way shouldn't be allowed, which, again, is just completely wrong. The guidance in the PPG on pre-commencement conditions is at paragraph 007, reference ID.
I've got the
21.8, yes, all of that. It says care should be taken when considering using pre-commencement conditions that prevent any development authorised by planning permission from the beginning until the condition has been complied with. This includes conditions stating that no development shall take place until or prior to any work starting on site. Such pre-commencement conditions should only be used where there is a clear justification. So that's what you need to ask yourself, which is likely to mean that the requirements of the condition, including the timing of compliance, are so fundamental to development that it would otherwise be necessary to refuse permission. Now, if Mr. Tamplin is arguing that these conditions as pre-commencement conditions are not justified, in other words, they are not necessary, the implication of that in the context of the PPG is that they are not so fundamental to the development permitted that it would be necessary to refuse. Now, that is slightly surprising in the context of much of the Rule 6 parties' other evidence. But if they are saying that we don't need pre-commencement conditions because controlling those things is not necessary, well, I think A, they find themselves at loggerheads with Oxfordshire County Council as planning authority. We have certainly accepted it would be appropriate and necessary to control those things. But when you go through each of the conditions, you will need to ask yourself whether the pre-commencement condition is necessary. And if you do decide to strike some out on the basis that they are not necessary in order to grant planning permission, well, so be it.
Mr. Perry, oh, sorry, there's two gentlemen, I don't know. Mr. Mitten. Oh. Sorry.
Hello. Yeah, sorry,
Sorry,
I haven't introduced
names?
myself until now. Yeah, so David Mitten, that's M-Y-T-T-O-N.
Thank you.
Solicitor at the County Council, dealing with planning matters.
Planning. Oh, solicitor.
Yes.
Thank you. So do you have some comments? Have you seen the document?
I have, Madam, yes, thanks. I would just concur with what Mr. Humphreys has said. The local planning authority's position, not surprisingly, is that all of the pre-commencement conditions that have been described are necessary. We wouldn't have been putting them forward otherwise. It's a very simplistic approach, but if we're dealing it in general terms at this stage, then that's what we would say.
Thank you. Did you have anything to add? No. Does anybody else want to add anything? No? Thank you. Mr. Tamplin, do you want to respond to anything?
Only very briefly, Madam, thank you. I think I agree with Mr. Humphreys about, quite clearly I do, in terms of the extract from the PPG, but the words that stand out to me are such pre-commencement conditions should only be used where there is a clear justification, which is likely to mean that the requirements of the condition, including timing of compliance, are so fundamental to the development permitted that it would otherwise be necessary to refuse the whole permission. And I think that that is simply a reflection of the way that the scheme as a whole, despite the fact that we have had a 9-month gap since the matter was called in before coming to this point, so many of them, of those pre-commencement conditions, could have been investigated and maybe the matter resolved in some way so that the condition would not be necessary.
Thank you. So, unless there's anything additional, we'll move on from that point and just start going through. Mr. Hancock, are you about to say something? No. Right. We'll move on and just start going through the list and keep it. I'm not going to read them out unless we really need to. I think everyone's got a copy. So the first condition is just the standard condition. The second condition requires compliance with the approved drawings and plans, and I can't. That obviously needs to be attached as a schedule, doesn't it, somewhere? What I would ask, the supplementary statement of common ground is the one I asked for you to list the plans in, because there's been a number of amendments through the course. Can I ask that the parties review that, and if any of these other conditions mean that there's further amendments to those needed, maybe they need to be taken out. I don't know if I've explained that very well.
Madam, yes, we will, along with the County Planning Authority, make sure that we check all the plans and the plan numbers, and if there are any consequential changes, then obviously I'm sure we will try and pick that up, and Mr. Perriam will, I'm sure, be very vigilant in making sure we get all the right plans.
Yes, I'm just concerned that could be seen as quite an open-ended condition, but so long as it's clear what does need to be complied with and what we're waiting on further information for. In general, my comments have been adding in the reasons and the references to the policies. So number 3 is about a construction environmental management plan for each part of the development. So each part of the development, do we need to say what that means, or is everyone happy? That's very clear. I'm assuming it's the 4 different elements. I don't know if anyone's got any thoughts as to wording to make that slightly more precise.
Madam, yes, I think the 4 parts in this context certainly does mean the 4 elements. I'm not sure whether for some parts there's any sort of sub-part. The idea is that you can't start a part of the development to which you know, the
Each of the
but-
four, if I can leave it with you to think of some word, but each of the four elements is probably the wrong word to put in
yes.
a condition.
It may be we could put in an informative that just describes what the four parts
That might be a way
are.
forward. Or if they're identified on one, I have got, that's the viewpoints plan, but there is a plan that labels it, doesn't it?
Madam, can I just interrupt and just make a
Certainly.
suggestion?
Absolutely.
As part of the inquiry, certainly Mr Humphreys has referred to it on a number of occasions, the local transport connectivity plan identifies the components of the Hif1 scheme, and maybe as a footnote or part of the condition, you could refer to the LTCP. and that definition of the components.
So if somebody provides the reference, I'm happy with that as a solution. And as I say, there was a version of this plan, but that identifies the four parts. I don't mind what it is, but I don't want it sort of picked apart later. So you've got to come in with all four parts. Sorry,
Madam,
Mr. Mitton,
well,
isn't it? Oh no, it's
sorry.
Mr. Perriam.
Well, the description of the development, and obviously, please, anybody correct me if I'm wrong, does set out the four elements. So I don't know whether the condition just reference as set out in the description of the development or something like that.
That's probably a good solution as well. That might be. People are happy with that as set out in the description of the development. I think that would be. I
that
think
certainly
that's
works.
yeah. Thank you for that, Mr. Perriam. Based on the, so there's a really long list of what needs to be in it, and I just question, because it's within the gift of the local planning authority, whether it all needs to be listed like this. But in terms of, I've just made a few comments. So one about the working hours and locations. Working hours and location, that's often preferred as a standalone condition. I don't have a preference, but it's often considered that it's easy for the public in particular to know what's, not even submit the details, but the working hours shall only take place within there. I don't know. I'm going to put my question to you, Mr. Perriam.
I'm happy, madam, if you think that's more appropriate, but I mean it's not unusual in my experience for SEMPs to have that as part of the overall SEMP condition, but I understand what you're saying. If you think that's more appropriate, then it'd be absolutely fine, I think, by the local planning authority.
Okay. Would you be able to let me have a copy of some indication of the hours that you would put on if we're limiting the hours? It doesn't have to come today, but Mr. I'm sorry,
Yes.
I'm putting my questions to...
No,
I just
I
say-
think Mr. Maddox will probably
Mr. Maddox.
want to respond.
It's only to say, Madam, that the proposed working hours are already set out in the outline environmental management plan, which is core document C.1, Annex 1.
So we could... Right, so it's the outline...
Environmental management plan.
Annex...
Core document C.1, Annex 1. And I would refer
Annex.
you to table 3.2. And in table 3.2 there are references on the left hand side, and it's reference C-G4.
Thank you for that. Because what's just occurred to me is there will be some night working, won't there? And weekend working and things.
I think it does mention there's exceptional hours as well.
Yeah, that might be better to make a reference to that, to
And-
it's set out already.
Madam, whether it's a separate condition or not, obviously the condition itself provides that the SEMP shall be based on the submitted outline, and therefore
Yes.
those hours are secured. So it's simply the presentational point of whether it's better to have it separate or contain it. The reason very often these things are in a SEMP is because that's what the contractor then has, and it's all set out for the contractor in one place.
I think for a project like this, that it might be preferable to leave it where it is then, because we've got they're not typical hours.
No.
They're varied. Thank you for that. So I will say all my comments are comments, they're not instructions. I'm just put them out in that way. So the next one I had, it's about the reinstatement of temporary land. Is that, do the parties have a view as to whether that will be a separate condition? Because I get this is land that won't form part of the scheme itself. Or are you happy with it? You feel you have adequate control?
I think, again, it's the sort of thing I'd normally, in my experience, see in a SEMP. So, I would be happy with it there, I think.
Okay. If anyone's got a different view, just interrupt. It's probably best. So, so the next one is about continuous access to a third party and development where existing range access arrangements are affected. And my comment on that is that's the point of the side roads order, surely. But I start with, if I call you, Mr. Maddox.
So we would prefer it to be kept as part of the KEMP, and I believe David's also commented on it in the same way.
Sorry, your microphone's not.
Apologies. We would prefer it to be kept within the KEMP, and I believe David Perryman shares that view as well.
Right. Okay. So the dust management plan, I've seen that in the ES. Does it need to be listed here?
It can be listed here because it will form part of the KEMP which is a sort of umbrella document for all of the management plans, and it is again mentioned in the OMP. Again, it's in table 3.2, and the reference is C-AIR1.
So that's in document again, CD C.1 Annex 1, table 3.2, and at that reference.
Thank you. So the next section relates to the impact on the river, and it relates to part 2 of the development. And my thought on that was that many of those matters are probably covered by the bridge order. So do they actually need to be in this plan?
I can probably comment on that one again as well, Madam. I believe these were suggested for inclusion in the KEMP by the EA in one of their most recent comments on the application, which is core document E65.
But they might be suggested by the Environment Agency, but that doesn't justify them, the fact that they've suggested them. I sort of had a look at them, and I can't see much that wouldn't be covered by the bridge order, but does the local planning authority have a different view?
I don't think we have a different view. I mean, obviously we wouldn't normally, when we're not engaged, obviously, with the bridge order or the side road orders anyway, so...
Are you satisfied it would be covered by the bridge order, or do you feel that they need to remain here?
Those that are dealing with the bridge order are of the view it would be, so I would say that's fine, but like I said, I don't think we're not engaged with the bridge order, you see, so I can't really comment on the bridge order and what that does, because it's not my area.
No, and actually it's the planning permission, isn't it? It would be covered by the bridge order, but that's assuming the bridge order will be confirmed. I suppose if it's not confirmed, you can't build it. This
Madam, I think our position is that, you know, if the EA want to see this here, we're perfectly content for it to be here, and then that does not prejudge what is or is not in the in the bridge orders. So clearly, you may form a view when you've heard all the evidence on the orders as well that there is some overlap. So, you know, we're not pressing for this, but neither are we resisting it.
Okay. Biodiversity, so it is a construction environmental management plan, and I'm just asking whether you need to distinguish, certainly on the first bit you don't, whether there's any elements to this section that you need to distinguish during construction. So you've got implementation of protected species licenses, which obviously that's something that you need to comply with anyway. But identification of biodiversity protection zones, I didn't see those in the documentation. So if we go down to the fourth bullet point where you've got details of measures to be taken to avoid or reduce impacts. No, you've got, sorry, it is during construction. I obviously didn't read it properly.
Because it's in the construction environment management plan, I think everything is during construction.
All right. Thank you. So the next section there is the landscape and trees. And as I've commented, and I think I've commented on some subsequent conditions, there's a lot of tree protection plans. They've been updated, they've been revised. There's quite a recent note, I think, identifying trees that are no longer due to be impacted, and that how much of this information needs to be put in here? Does it make sense as part of this condition? What I would like to avoid would be, I mean, do we not just need something saying that complies with the arboricultural impact assessment as set out? We've got quite detailed evidence from what I've read there, and just trying to avoid evidence that you've already got having to be resubmitted and screened and checked by the local authority as well, because it's an impact on them. Yes.
That the LPA perspective on this is that the tree protection plans and the arboricultural impact assessment require a review following contractor involvement and also a review of the tree locations.
Why does it require a review of the tree locations? If they've been plotted in a survey, surely that's their location.
I think I might be able to provide some background to that. So there is a paragraph in the arboricultural impact assessment report that states that some of the stem locations of the trees have been estimated from aerial photography. And if you understand, when looking down from above, the canopy is essentially, if we imagine a circle, that stem could be within the circle. So the exact location of the stem for some of the trees has not been topographically plotted.
Thank you. So then, has anyone else got anything further they want to say on condition 3? Yeah? Okay. Condition 4, I've just added the wording. The reason, rather. Condition 5 requires a topographical contour plan or plans of the final proposed levels. There are cross-sections that show changes in levels. Is there a reason that we need that? And is there a sort of a Rochdale envelope that encompasses any slight variations?
Madam, I think the central point on this is less to do with any Rochdale envelope than the fact that it's talking about topographical contour plan or plans, and this is an area where there is a lot of existing working on the land, both extraction and indeed filling, and therefore it is perfectly possible that some of the levels might be different. I think the purpose of the plan is to make sure that the levels of the land at the time that that part of the development is commenced is properly known.
And is it likely to result in any sort of, given the reason, which is unacceptable levels of harm through incongruent landforms and associated effects on visual amenity, are the changes likely to be that significant to that degree?
No, I mean, we have no reason to believe that they will, but that's another reason for having the condition, so that the local planning authority can understand that and have control. So the development shall thereafter be delivered and completed in accordance with the approved drawings.
Thank you. Mr. Perry and Mr. Mitton, do you want to add anything?
Madam, my thought was that cross-sections would show only vertical levels at specific points rather than a full representation of contour that would be given by contours. In which case, topographical contour plans would be useful.
Thank you. Condition 6, there were some comments from the parties, so that will be on one of the key documents. I've obviously got that. Wrong. I know. It's the condition orders changed, hasn't it? That's so. Let me see what the original condition was. So it's condition 28 is where the comments would be found. So this is the condition about lighting. Prior to the erection of lighting on any part of the development, notwithstanding the details submitted with the application, I've got the reasons, I think. I've got the reasons, but there were some comments. I'm not sure which authority it was, suggested
myself,
that we added...
Madam.
Sorry?
I think it was myself.
Oh, right. Thank you, Mr Butler. Do you want to explain?
It was a point I was making in my proof about potentially not having lighting between what I call Hartright House, which is on the stretch of the road between Hill Farm, effectively, and the River Thames. Not putting lighting in that area as it crosses, in essence, a rural area, although, of course, we need to bear in mind that there are the landfill, minerals, rail sidings, etc. there, as I mentioned yesterday. It's a matter of giving consideration to that, I guess, and balancing that against the safety of users of the road, particularly cyclists and walkers on dark evenings, dark mornings, for example. It's something I've suggested in terms of limiting visual impacts.
So your suggestion is that lighting shouldn't be provided there, or should be provided?
Shouldn't, was my suggestion. So I think in the comments that the Vale of Whitehall sent back to the County Council was that the wording was at the start of the condition.
Prior to the erection, sorry. With
the exception of that part of the development between Hartright House, and I give an address for it, and the River Thames, which shall be unlit, and then it goes on to prior to the erection, etc.
With the exception of unlit prior. Obviously, I think that would need to be, that wording wouldn't quite work, would it? But, you could say that should be on lit, and then prior to the erection of any lighting on any other part of the development of the scheme, something like that.
Yeah, that's what I was suggesting.
That's what you meant.
It's for your consideration. If it doesn't go in there, I don't think it's a situation where you should be recommending refusal of the scheme. I just thought it could be something there that would limit some of the visual impact.
Thank you. Does the planning authority... Sorry, you are the planning authority.
Well...
oh, no, you're a separate planning authority.
The county, so this is county as council planning authority. I don't know if Mr Humphreys wants to say something first. No. My understanding has always been that the desire would be to have as much of the route unlit as possible, but for safety reasons, there are elements that just have to be lit, and that those have to meet certain standards which the County Council's Highway Authority has set standards. That's my understanding, but then that's probably something Mr Maddox might want to enlarge on.
Okay.
Madam, Mr Maddox can talk about whether or not there should be lighting. We have, in case you wanted to impose such a restriction on lighting, come up with a form of words which
is that the document that was emailed? Or?
I don't think so. This is just
right.
something I've got in front of me. We can obviously let you have it and we can tell you what it is.
So what are your suggested words?
It's prior to the erection of any lighting on each part of the development, and notwithstanding the details submitted with the application, details of the proposed lighting in that part of the development shall be submitted to and approved in writing by the County Planning Authority, taking account of areas to remain unlit, including, and then there are, I think, two that have been identified, the viaduct and bridge sections of the bridge across the River Thames, and the scheme between Hartright House and the River Thames Bridge, except for where safety standards require lighting at proposed junctions. And then I think the condition then continues, I think, as per the original wording.
Thank you for that, Mr Humphreys. Mr Butler,
I'd be satisfied with that as that condition, yes. Thank you.
Thank you. Mr Perriam, Mr Mitten, whoever?
Yes, I don't think we'd have any...
I think that would be preferable wording. So if
Madam,
we could
that wording we can, because I appreciate you won't have been able to write it down, but we can send that to the programme officer So we'll just take an action to send that wording to the programme officer for condition 6.
Thank you. So the next one, which is 7, and that obviously it refers to another condition, and this is about the noise barriers. So I've got the reason. And does it need to refer, that was my question, does it need to refer to the locations where noise barriers are shown to be either on the submitted plans or within the ES? I would suggest probably on the plans.
Yes, I think I would agree, Madam. And again, we've created some suggested wording to point to the relevant parts of the environmental statement and the outline environmental management plan as well.
Right.
I haven't kind of run through that, but we can send it to the inspector.
You can,
Okay, do you want me to
if you could just read it now
read it
so
aloud,
everyone
yeah.
can knows
fine.
what it is. And
So it begins sort of as it is before. So it's subject to the consideration of any details submitted pursuant to condition 34 and prior to the first operational use of each part of the development, noise barriers and other noise mitigation measures, including low noise surfacing shall be installed in accordance with, and then there's 2 bullet points, the location of noise barriers and low noise surfacing shown in environmental statement figure 10.1 and the heights stated in outline environmental management plan table 3.3 scheme design, and it gives the references DN-2 and DN-3.
thank you for that, Mr. Maddox. Does anyone have a comment on that? No? Great. So the next one is, it's listing the 3 bridges, and it's asking for details of the external appearance, including the colour of the parapets. My thought, and it's probably not on what I sent out to you, but that we should probably be clear that it should include the abutments. And the question I had on the bridges was whether we needed anything about maintenance. I'm thinking we've got some large areas of concrete, and I don't know how susceptible they are or the proposed materials are to sort of graffiti, things like that, whether we need that in the condition or not. But I do think we need I think the abutment should be included, construction of the structures, including details of external appearance, including the abutments. But I don't know if anyone's got a thought on that. Mr. Humphreys.
Yes, Madam. Again, we've come up with a form of words to replace the first part of the condition, reflecting your comment, and it's prior to the commencement of construction of each of the structures listed below. Details of the external appearance of the structure, including but not limited to the colour and decorative treatment of the parapets, illumination, not street lighting, finishing treatments such as textures to abutments, piers, wing walls shall be submitted to and approved in writing by the County Planning Authority. And then the condition continues. I'm not sure that something on graffiti is particularly
Maintenance is what I was thinking in order to address it.
yes, maintenance generally. I mean, the county council obviously has general maintenance requirements and duties in relation to its assets, which will include these bridges. For my own part, I'm not convinced that we need a planning condition that we have to maintain our assets. We
Thank
clearly
you.
have legal duties there.
Okay. Does anybody else have a further comment? Mr. Mittens.
Madam, obviously the condition does refer to maintenance, which is obviously why you've highlighted it. Certainly I'm sure that graffiti would be a concern to the local population, and I see no reason not to include it. Removal of graffiti could be specifically referred to. I think that would be a good idea.
Thank you. Is there anything further?
Madam, I'm sorry, despite what I said just now, could I just come in on this one? Because I think it is this one that I really am concerned about for two reasons. Not in respect of the Thames Viaduct or the Appleford Viaduct, but the Science Bridge. And if I could refer you back to the note of the PIM, paragraph 21, that's the pre-inquiry meeting summary note, which your predecessor issued, I think, at the end of November, beginning of December, where she said, it would be helpful to explain how the LPA considers the design of the bridge can be enhanced by way of a condition when the proposal is a full application. That leads me to the point that I think has been made elsewhere in the inquiry, that this bridge is going over Network Rail mainline tracks. And my understanding is that Network Rail will decide what it requires in terms of the design of the bridge, not the colour, but design, which is a much wider point. I'm concerned that we are likely to end up with a situation where the LPA wants to do something to improve the design, and I'm entirely in support of that. But Network Rail does have the right to dictate terms in those situations, and I'm simply worried that that condition in respect of the Science Bridge, whether it would actually be enforceable.
You're suggesting that if there was an agreement on the appearance of the parapets or something, that it might be that Network Rail wouldn't allow those particular elements?
Precisely.
Yeah. Mr. Humphreys, do you want to comment on that first and then the local planning authority?
Yes, my understanding, Madam, is that Condition 8 in relation to the Science Bridge isn't intended to encompass a wholesale redesign of the bridge. This is external appearance relating to various things, finishing treatments, textures and so on, abutments. But you'll see that Condition 8 Roman 1 does say, brackets, taking into account the constraints of Network Rail design requirements, including enhancements to the design. And therefore, anything that is done, Mr. Tamplin rightly reminds us, is obviously subject to what Network Rail require for rail safety and other reasons.
Thank you. Local planning authority?
I don't think I've got anything to add to what's just been said. Thank you.
Thank you. I didn't have anything on 9. If you've got comments in areas that I haven't commented, do raise them as we go through. 10 requires the visibility displays, and it just requires them to be provided
Madam,
in accordance. Sorry.
Apologies, we did have one suggestion on number 9. On
Number
condition
9. Yep.
Yes. Because I believe the condition requires the footways, cycleways to be opened prior to first operational use of the development. However, we were concerned that it may have undue constraints on condition sequencing.
So it may have a...
Undue constraints on the way the construction of the scheme is sequenced. And also certain elements of footways, cycleways may be completed before others. So essentially they would... So some of those would be a footway, cycleway to nowhere, essentially. So we've provided some suggested wording to make the condition more aspirational, in that the county council will seek to open those areas first, but it doesn't. It's not a pre-commencement condition.
What's your wording?
The wording, Madam, is that opportunities should be sought to open footways, footpaths and cycleways shown on the approved drawings prior to first use of the scheme by vehicles, where this does not create safety hazards to active travel users or impose unnecessary adverse constraints on construction sequencing. Because obviously, Madam, this will be, you know, a live construction site, and safety is important.
Thank you.
And again, as with all of these, we will send them in one document to the programme officer.
Yes, I hear your view in a moment, Mr. Perry. I think if we can, where you've got these suggestions and they've not been shared previously, if we can have them in one document, when would we be likely to get that document?
We've been working on them literally up until about half an hour ago.
So we should be able to have it early next week?
Oh yes, yeah. They all exist in a written form, but they're part of a much longer note.
So what I suggest is if you share them before next week, and then if there's any additional comments or you've looked at the wording, that you, because we're holding the inquiry open,
of course,
maybe by the end of next week we could have any additional comments. But if you copy your comments to each other, and obviously don't repeat comments we've already heard, you know, just on the wording. But Mr. Perriam.
Obviously I hadn't heard.
No, and that's what I'm saying. There's a lot to take in as you're going through.
I mean, the reason for the condition, I think, reflects what I thought had always been said, was the intention that this would be to obviously facilitate alternative means of transport at the earliest opportunity and make sure that that came into effect. So I think I would want to see the wording in more, think about it in more detail before I could say we necessarily are happy with that.
Okay, and the potential conflict with condition 9, that you're saying it might have a problem, is that, can you explain that to me a little bit more?
Of course, yeah. So we were thinking about how we would implement the condition, reading its wording, and say, for example, if you opened one section of a cycleway, but the end of the cycleway was not yet operational or constructed, people will be using a cycleway that would go essentially finish, and it wouldn't be the whole scheme, for example. And then therefore, if we are looking, for example, if you take the A4 130, where there's roundabouts that are both online and offline of the existing roads, those cycle paths, footways go around those roundabouts, so it may create undue difficulties in constructing the roundabouts themselves, or the parts of the scheme, for example, if we needed those to be open first. I understand that obviously it's, and I agree with David that it's to encourage active travel. It just may be.
So it's that the cycle routes don't, and pedestrian routes don't precisely follow the line of the road. They do in places, but there's places where they deviate.
Yes.
And thank you. So we're moving on to 10. I think my only comment on that was should be provided. It's seeking the submission of visibility displays, but they're already shown on the drawings, and that was my question, was should we not just require visibility displays to be provided in accordance with the plans?
Yes, Madam, we should. And the wording would be visibility displays shall be provided in accordance with highway visibility design sheets 1 to 19. The visibility display shall be maintained unobstructed as approved so long as the development is in use by motorised vehicles.
Thank you. I'm assuming there's no... so just coming back down to the LEMP, seems to have made some typos there. So you want it based on the outline management plan. But again, I think some of how much of this information that's been sought has already been submitted, and is it necessary to include it?
Do you want me to speak to this one a little bit,
yes.
Madam? So yes, it is correct that an outline, it's actually an outline landscape and biodiversity management plan, although the condition requires a landscape and environmental management plan. So there's a small distinction there over the wording. But however, so it only provides sort of outline details, and there's, I think, there's some more detailed management measures that will be detailed within the detailed management plan.
Okay.
Including such things as maintenance schedules through construction and operation, and what those exact management actions are.
Thank you. And I think it's Mr. Group's evidence at paragraph 3.40 suggested a handover environmental management plan. Is that required?
So that would be detailed in the KEMP. Indeed, yes. The way it usually transpires is you have an outline, you have the KEMP, and then you have a handover environmental management plan, which essentially hands over the responsibility to the, in this case, the Highway Authority.
And that would be embraced within the earlier
The KEMP would set that lineage out.
Thank you. Lifespan of the management plan, presumably that would be a 30-year, or would it be longer?
I think this is the lifespan of the plan will be shown in the management schedule, and I think maybe you referred that this may be related to BNG, and obviously there is a specific condition related to biodiversity net gain. So if you were minded, we could remove that specific bullet point of the.
I just think my concern is that if you've got 3 different conditions, all with different time spans, or even the same time span, that it's clear what's to be provided. So if it's not needed in here because it's adequately covered in the BNG condition or some other condition, then I think it probably should be removed. And then, did you need to say no? Preparation of a work schedule. I'm not sure what's being sought by a work schedule.
So again, that's I sort of touched on that briefly before. So it will be a detailed plan of when certain management actions should be undertaken.
So that relates to their management?
Yes.
Thank you. Thank you. And then coming further down the page, details of the legal and funding mechanisms. I don't know what's being, what the concerns are in relation to that.
I wondered whether the LPA may be able to provide a bit more light, but I thought it was possibly in relation to securing offsetting, which is covered by condition 14, so it's potentially a bit of a duplicate.
Do you know, Mr. Perry, it might be something that applies on a regular, if I call it a regular scheme, but not a larger.
I ran, as you probably anticipate, these points past our technical advisors, and the comment I had from the ecologist was to ensure the measures are in place to ensure long-term maintenance and creation of habitats. But if that's covered off
that would
adequately elsewhere, then equally it doesn't need to be here, I would say.
Thank you. So the next one, the next 2, I just wondered whether they could be linked. They're, the updated protected species surveys are required to be submitted. and then the biodiversity mitigation and enhancement strategy. Again, I think it just comes back to we've got several conditions trying to do the same thing, and just either just dealing with a discrete part or pulling them, not duplicating each other, because it can be, if you've got a contractor, they could think they've done it, whereas there's a little bit more to do in another condition. I don't know if you've had a chance to look at that.
I was just about to hand over to David Perrin because I believe he's spoken to the relevant officer.
Yes, so again, I raised your query with our ecologists. They are of the view these two conditions could be combined.
Sorry, Mr. Perrin.
Sorry. Yes, so our ecologist was in agreement that when they looked at it again, they felt you could combine these two conditions, and I've got some suggested wording. Do you want me to read that out?
Yes, please.
Okay. So, prior to the commencement of construction in each part of the development, a detailed biodiversity mitigation and enhancement strategy shall be submitted to and approved in writing by the County Planning Authority. The strategy shall be based on the mitigation measures set out within the Environmental Statement, Volume 1, Chapter 9, Biodiversity. If the baseline protected species data is over 2 years old, or in the case of a badger survey when it is over 6 months old, then the surveys will be updated and used to inform the detailed biodiversity mitigation and enhancement strategy.
I think that's probably preferable
Yep.
to what we had. The only other comment I've got is that chapter 9 was updated by one of the Reg 25 submissions. So I don't know if we'd put a date in or...
I must admit, I did look for that, and I couldn't put my hand on it, but of course I've got a
right,
document, so if somebody can give me the direct reference, then that's fine.
Right, I haven't got it to hand at the minute, but we had... I'll try and find it and let you know. If you could share that condition with the applicant, then it could all be rolled into the one document if they're happy with it.
Yes, madam. We had slightly different wording, but
Oh, right.
but I'm sure that the local planning authority's wording may be perfectly acceptable. It'd be surprising if we independently came up with exactly the same words. And so if we can, we'll agree that and just include it in our document.
Yes, thank you. Just biodiversity net gain on condition 14, I was what I wanted to be clear was, are you seeking 10% across the scheme as a whole, or 10% for each element of the scheme?
Well, our view is it's
Both.
10% across the whole of the
Whole
development.
of the scheme.
Yeah. I think
Right.
that's the applicant's view as well.
I would agree with that.
Thank you. And the updated metric, I suggested that maybe we needed to amend it. I don't know it's going to change again, but...
We could do, but they do change quite quickly, so maybe it's worth just wording that says the latest metric.
Yes. The only issue on that is if you've done two parts and the other, they've changed between two parts. The latest at the time of the first application, I'm quite relaxed whichever way you do that, but they seem to have settled for a little bit, but they might move on again.
I would rather we reference
Yeah.
4 rather than 3.1, which we used.
Definitely. So I'll leave that with you just to see what you feel, and if we can just prior to commencement. So your assessment will be for the whole scheme, and that needs to be submitted before you start any part of the scheme. That's my understanding of what I'm reading here. Is that correct? Right. So perhaps we could just add in some clarity that it's for the scheme as a whole or something, just so that that's clear. Yeah. And then the last bit I said, is it needed? That it should take into account the landscaping scheme. I mean, do you have a view as to whether that second part, referring to taking into account the landscaping scheme, is necessary in the tree surveys?
I think it's fine to include the reference because B&G is obviously linked to landscape and tree loss as well, so the identifying the link is fine, I believe.
I think, as I've heard more evidence, there's Little Roman 2, where I've asked, is it in respect of river mitigation only? That's what the offsetting's for.
Yes, and we've got some suggested word, and it just refers to riparian habitat to make that specific.
Thank you. Can you read it out just in case there's any initial comments?
Of course, yes. So that would mean that Roman 2 would be amended, and it would say a certificate confirming the agreement of an offsetting provider approved by the County Planning Authority to deliver a biodiversity offsetting scheme for the provision of riparian habitat. So that's the amended wording, that cannot be delivered on site.
Thank you.
Sorry, Madam, I did raise that question with our ecologist, and her comment, I'll just read out her comment because it's not quite what you've said, I don't think. So she says she believes it's referring to any units that cannot be delivered on site. So I think
just any habitat units.
Yeah, that's what she's saying. Now I'm not the expert. I'm only reporting that was her comment on your comment.
Thank you. I think the evidence we've heard at the inquiry is that that all of the other units can be delivered on site, comfortably achieving 10%, quite in excess of 10%, aren't they? And it's only this one area.
Yes, that's what the latest biodiversity net gain assessment shows.
Okay, so okay, I'll have a look at your wording, and I think we're in agreement. I don't think there's any issue, Mr. Perriam, having heard the evidence. And I would prefer to keep as much of it on, and that's probably your approach, to keep as much on site as possible. Okay, thank you for that. So the next one was contaminated land, and I think my comment on that was that CD A14, and maybe I've not put the full reference in, I don't know, but it's got details of the investigations that have already been carried out, including intrusive investigations, and that whether the condition should really just be more focused on the remediation strategy, but I might have missed something there, I don't know. If I start with the applicant.
I was going to defer to David because I believe this was suggested by an EHO.
And Adrian might want to possibly comment, I don't know, because I tracked this back to the consultation response, or one of them, that came from the Vale or White Horse District Council, which included comments from their EHO, and it arose, I believe, this condition from their comment. So the EHO has been made aware of your comments, so shall I just read out their response to your comment, because it's a bit technical, and see what you make of it. So he or she has said, as per comments in the document, that the consultation response, a groundwater risk assessment was planned to be undertaken to better assess the level of metals contamination, and I recommended the hydrocarbons should also be measured, given the identified potential areas of contamination, as stated in the Phase 1 report. Limited gas monitoring was undertaken, and given the potential risk to workers in enclosed spaces, further gas monitoring was required to establish worst-case scenario for the site. Where unacceptable risks were identified, a remediation method statement, RMS, would then outline what measures are required to sever is what he means, sever these contaminated linkages. Following approval of the RMS by the local planning authority, the remedial measures would be expected to be followed as per the report, with a verification report to follow outlining exactly what measures were completed and that all identified contaminant linkages were severed. And as I say, I don't know, Adrian, if you want to say anything on that.
Okay.
I don't think there's much I can answer it. That's what he's our contaminated land officer, and his comments, just to direct to where his comments are in the evidence, that at L3, which is
Just
the
bear with
Vale
me.
White Horse Stoneter case.
Does,
Yep.
let me just... L3,
L3,
Yeah.
L for Lima. 3.
what page?
Paginated 33.
33.
They're quite lengthy, madam, so you may not
Yeah.
want to read them now.
So do they...
They were his
I
original
think what my
comments.
question is that having looked at the documentation, there seems to have been quite a lot of work done already, and I don't really want a condition that requires all that work to be repeated. You probably don't either, because if it's repeated and submitted, you've got to assess it. So are we able to be more precise? Can I leave that with you? So what you're... From what I can understand, there are some areas where you feel that further information is required or further investigations required, and if we could look at that wording and pin that down where we do need the additional work, and if it's considered that it is better to leave the wording like this, then we can do so. But I do have concerns where we've had quite significant investigations and we seem to be asking for that work to be done again. But I don't know, has the applicant got a view on that, or you're just deferring?
Again, I would defer.
Okay. Can I leave that with you? Mr. Perriam, could you let me have a copy of what you've read out? And I'll take that forward. So I've got the original information. I've got the information that's on the website or submitted with the application. And I can then look at those comments and see. So I think if we move on from that, and I will have regard to the comments, if you email them to the programme officer, and we'll give them an inquiry document reference, just so that the Secretary of State can see them if they wish. So 16, I didn't have anything. 17 was really just whether the assessments and risks of infiltration to controlled waters was covered in the assessment of runoff and spillages that's already been submitted. Don't know if anyone's got a view on that.
Yes, madam. So I think it's typical for this kind of assessment to be updated prior to construction because it relies on water quality monitoring data. So it's a bit like ecology surveys, essentially, which the baseline may have changed. So it's more of just a check prior to construction.
Thank you.
Oh, yes, as well. I believe you referenced CDA 17.43, but I think you may be meant for... No, yes, you may be meant 4.2, sorry.
4.2.
Yes,
Thank you.
because I believe it's Appendix 14.3 of the ES, so there's obviously, it's quite close.
Thank you. 18, I've got nothing. 19, 20, do stop me if you've got comments. 21 is the next one I had a comment
Madam,
on. Sorry.
Apologies for
I've
interrupting.
gone too fast.
Condition 20 was one suggested by the EA, and we felt it was a little bit too wordy and have come up with some wording that sort of makes it a bit more concise, so we can share that around.
Yes. Can you just run through it quickly now?
Yes, of course, yeah. So it simply says that the development shall not be carried out other than in accordance with the mitigation measures set out within the following documents, and these measures should be retained and maintained throughout the lifetime of the development. The submitted flood risk assessment, September 2021, flood risk technical note dated 20th July 2022, and flood risk technical note additional information dated December 2022.
So it's just taken that initial list out.
Yes, and sort of summarising the end bits as well in the first part.
Yeah, I remember looking at that and thinking something similar, actually. No. So that's 21. So that's just talking about compensatory flood storage and altered or proposed culverts to be inspected and maintained through the lifetime of the development. Is the access to these areas shown on the plans, was my question. I wasn't quite sure.
I believe access is shown to sustainable urban drainage features. So, for example, there's a number of drainage ponds along the scheme. Access is not shown to culverts, I believe.
Do we need it, I suppose? Does it need to be on there, or is it?
It's not my area of expertise, unfortunately. I believe the condition was requested by the EA, so that's why it's been included.
Right. I'll have another look at that then. Condition 22, so it's about the hard and soft landscape works. So there's a reference on it to the landscape general arrangement drawings, and I thought I heard, I think they're called the preliminary landscape master plans. I think that's their title.
That's correct, yeah.
So just amend that to that. And then we've got a reference to climbing wall, and somebody suggested that we should probably replace it with a green wall.
I would agree.
Yeah, thank you. I think it's one of the districts. And the first bullet point, I felt was that information, the first part had been provided, and that the second part could be part of the scheme, telling them what they should consider for the scheme. Doesn't really take us anywhere.
I think in terms of providing detailed master plans, I think the only difference between the two would, a detailed master plan would include detailed mixes of plants, so seed mixes, percentages, that kind of thing. It would show the same details that's on the preliminary landscape master plans. So I think that maybe that first bullet point just explains what the preliminary already shows, and that the detailed should include that as well.
Thank you. So on the final bullet point in there, it talks about landscaping proposals. I just felt, given the nature of the scheme, do we need that level? Do we need all of that information, or are we better with a more bespoke condition? The landscaping is quite an integral part of this proposal, isn't it? It's not sort of just what's left, and whether you feel we need that, or whether there's an alternative wording that might be more appropriate. I appreciate there is a need for some of this detail.
I think we've suggested some wording. I think it'd be a bit difficult to go through it now, because I've sort of crossed out certain things that I think have already been provided, so it would reduce the list.
I think so. If you could have a look at that, and we can revise from there. So and then the final paragraph of that condition talks about replacing the turfing and the seeding within a 30-year period, and I'm assuming that's to tie in with biodiversity net gain. So, Mr. Perriam, did you have any comments on the other bits of that condition?
No, that's fine. I was just confirming what you just said.
Thank you. So, 23, it's the point about the trees again. So, I'm assuming that's the same response that I had earlier about.
Yes.
Thank you. So it's 24 is asking for a detailed arboricultural method statement. And what are the concerns with the statement that's been submitted? We've got tree protection plans, the location of the fencing shown, working areas. What other information is it that you want with that condition?
I believe with this one, so an arboricultural impact assessment has been submitted, which outlines details of tree protection measures, so specifically Appendix E, F and G, and, as you've referenced, the tree protection plans. But obviously we would, the arboricultural method
There's a
statement...
method statement as well. It's appended to something, I've seen it.
Ooh, I'm not sure of the reference to that then.
Okay, you think you haven't. I'm sure I looked, but I will have another look.
Yes, apology, I thought an AIA had only been submitted with
If I've
outline
got
measures
it.
provided.
Not sure if I've got it to hand, but I can't find it quickly, but I thought there was a method statement as well, an appendix. I think it was in a later, because the tree information's been submitted at more than once, hasn't it? I think twice in Reg.
Yes, it's been
25.
revised throughout the determination
and
period.
I think it's appended to that. But so if it's not been submitted, I understand why you need it. If it has been submitted, Mr. Perry, was your thought that
Well, the
it's not
same.
been-
Our people say they can't. Well, they haven't found the AMS either. So if
Right.
it is there, then that's fine, I think. But if it isn't, then I think the condition does work.
I'll double check, and what I'll try and do is let you have the reference on Tuesday. Okay. So the next one I think I've got a comment on is 26, and that's the climate vulnerability risk assessment table. Just wondered if right, my comment relates to LA 114 and whether we needed a full title or a date. The condition asks for a table, I've said, but the text implies an assessment. I think I did look at it, and there was some information on these matters. Have we got any comments on that?
Well, again, I got our relevant expert to look at it. They think the condition could be just reworded to remove the word table. But I haven't discussed that at all with the applicant, so they may, have something to say on that.
Yeah, we'd be happy with that, obviously, and with the inclusion of the full title of DMRB, LA 114 climate with the date, yes, and remove the reference to table.
Okay. So can you agree and submit some revised wording?
Yes. Yes, so we've got some proposed wording, so I believe we've just got an update. It's not. I'm not going to read the whole thing, but it essentially just says an updated climate vulnerability risk assessment should be submitted to and approved in writing by the county planning authority. So it just essentially again removes the word table.
Right. Okay. Thank you. Anything further on that, Mr. Perry? No. So the next one, really, my comments apply to 27 and 28. It's about the restoration schemes for the there's two of them, aren't there? One's for Sutton Courtney landfill and one's for Bridge Farm Quarry, and it's this point that was raised in evidence about how that would work. Mr. Perriam, are you satisfied? Oh, Mr. Mitten, sorry.
Sorry, me this time, Madam. So we, the conditions are framed as Grampian conditions, of course. That seems the most appropriate way forward given that they involve revisions to other schemes. Applying the guidance, there's no reason to think the schemes could not be revised within the lifetime of the permission for the road. So your question, is this part of the scheme dependent on the action of another party? Our perspective on it is no, because the county council could make its own application to revise the schemes, and would obviously then have to serve notice on the landowners and other parties with an interest in the land. So although the conditions relate to the land of another party, they're not dependent on the actions of another party, is our view.
And is the planning authority satisfied that that will, the issue that's been raised is it might impact on the existing restoration plans? You will be satisfied with the outcome as set out in those conditions? Thank you. Does the applicant want to add anything there?
No, Madam.
Thank you.
Madam, I would just draw attention to the fact you will be mindful of this, that this is one of the points that Mr. Tamplin raised in his paragraph 13.
Thank you. And I think the only other thing, I know you've been in discussions and it's a Grampian condition, but in the event that you couldn't reach an agreement, what would happen?
Sorry.
I know you can put an application in and you've got to serve notice, but obviously to the reviser. Actually, just looking at the wording, it requires the scheme to be submitted and approved, but it doesn't require, it's missing an implementation clause, isn't it, I think? No?
Madam, I think that's because the separate planning permissions for those two sites would then regulate the matter.
Right, I see that. Do I have a copy of those permissions? I don't think I do. And if not, could I have them, or at least the relevant? I don't know how lengthy they are.
Take
some finding, but yes.
I don't know.
They're minerals.
I don't know whether they're in evidence or not, but if I will find them anyway.
Yes, that's we've got to make sure it can be implemented, that it will be implemented, not that it can be.
Madam, I would say, so far as we're aware, neither of the landowners have objected to the wording and have seen it. I think that's right, isn't it? That's as far as we're aware.
So, obviously, if you don't reach an agreement, you can still put it in and it can still be agreed. And that's, I think, why I need to understand about the implementation mechanism. Thank you. 29 and 30, they're the archaeological conditions, and again, it just seems that there's a lot of repetition between them, and it could probably be covered in one condition. It often is, these matters. I don't know if you've got a view on it, Mr. Perriam.
Well, I again ran this past our archaeologist, and I can read out what he's said, but the gist of it is he's of the view it should be two conditions. And
right.
that indeed is their standard approach in Oxfordshire.
Right. Can you read what he said then?
Okay, it's a little bit long.
Oh, right.
Okay.
If you just go, just the main points.
So basically says the two conditions refer to two separate parts of the archaeological mitigation, which are often undertaken years apart. Condition 29 requires the written scheme of investigation is agreed in writing before any development is undertaken, as this document will set out where further archaeological recording is required. As such, this is important, it is important that it's understood by the developer in advance of any development being undertaken. It is important that archaeological work is undertaken by an appropriately qualified and experienced specialist, and as such it is essential that the WSI must be produced by a professional archaeological company with experience of undertaking such works. Archaeology is a very broad discipline, and there are professional archaeological companies who would not have had any previous experience of undertaking such work, such as geophysical survey specialists and scientific analysis specialists. As such, it has been standard to add that they need to be acceptable to the LPA to ensure that they are suitably experienced. Once the WSI has been agreed, the applicant will apply to discharge the condition that the required work itself, however, would have not been undertaken or completed at this stage. The second condition requires that the work set out in the WSI is undertaken and that a report for publication and a physical and usable archive has been deposited with the museum. This is to ensure that the results of the work are published and the material available for any reanalysis in order to deliver the public benefit required to mitigate the loss of these archaeological deposits. This post-excavation work and publication can often take a number of years to complete, and there have been issues securing this nationally once the developer has had any archaeological conditions cleared. There have also been issues securing this through enforcement action where a single archaeological condition has already been cleared. In order to ensure that the work is completed as set out in the National Planning Policy Framework, we advise these two conditions so that the final publication and archiving of the results of the excavation, which will only be finalised a number of years after the final fieldwork has been signed off, so that these matters are fully secured to deliver the public benefit from this mitigation. So would you like me to circulate those words to
I would.
Joanna?
Thank you. So I think his point, as I understand it, that requiring the publication as part of this condition could delay the implementation. Is that?
Well, I think that's it. And he does. I'll just read out one sentence that I did read out, but I'll read it again. He says that there have also been issues securing this through enforcement action where a single archaeological condition has already been cleared. So I'm assuming he's aware of issues when one condition has been used and it's then not proved possible to enforce. And I haven't got any detail on that, I'm afraid.
That's fine. If you let me have those comments, does the applicant have a view?
No.
Thank you. The next one, 31, it's about the downgraded section of the A415 by the Culham Science Campus, and you're seeking the details of that. I'm just, my question really was whether that was necessary or whether it would, it seems to me that it's shown on the landscape plans and other bits would be picked up by other conditions.
Yes, so this condition was picked up due to concerns of local residents in the area. They were worried about antisocial behaviour such as fly tipping. So we looked at some more measures which would be within the highway boundary but aren't shown on the landscape GAs.
What is it you've got in mind as other measures?
Potentially planting, maybe making the carriageway narrower because it would only be to serve a handful of developments. We also would look at putting double yellow lines down there, which isn't actually part of this application.
Thank you. Does Planning Authority know? The next one is compensatory tree planting on land controlled by the applicant. And it requires it for 30 years. Can that be explained to me what's being sought? So this is tree planting outside of the development?
I don't know. Do you want me to go first? Well, basically, our technical advisors looked at it and they felt this could be amalgamated as part of condition 22.
Part of condition.
But that's not been discussed with the applicant, so.
Right. Okay, so that's actually about the surveys and the method statement. So is there agreement that it's not necessary, the condition? Is that what you're saying?
Yeah, yes.
Yeah? Okay. Thank you.
Madam, yes, sorry. Some additional wording would be required in 22, though, I think.
So, in terms of this planting, is it the planting that forms part of the scheme, or is it something different?
I believe it doesn't form part of the scheme. I think there was an aspiration to maybe within OCC's land ownership to plant compensatory tree planting. But I believe that was the case, David.
Yes, I believe the history of this was it was put forward by the applicant to address one of the concerns raised as a reason for refusal by the committee in July. So I believe this came out of a response that was then put back to the committee in September, that additional planting was offered up. So I think that's the background to it. But as I say, it might well be it can be then built into condition 22 appropriately.
Okay. Can I ask you then to agree wording for condition 22? Is there any sort of intended location for this planting? Has something been... No. Thank you. So we're not sure where and not sure what the planting would be. So the money, was it £50,000? I can't remember. Where there's a potential section 106, is it linked to that?
Madam, I think you'll recall when Ms Ash gave her evidence, she made it clear that she thought the planting which is included in the scheme, which would be subject to the LEMP and other conditions, adequately mitigates the effect of the scheme. What she then said was, however, the county as applicant was willing to make £50,000 available to be drawn down by local communities for other planting that they thought may be beneficial or an enhancement. And that was to be dealt with by some form of Section 106 obligation. The challenge on this is that there's obviously some difficulty with the county council having a unilateral obligation in effect with itself, an enforceability problem. We have tried to overcome that by having a unilateral where the districts would in effect administer and take the scheme, but the districts have refused. They've declined. In any event, our view is that this is not necessary, and therefore it is not strictly mitigation, it is enhancement. And we will invite you, therefore, to note it, but not take it into account as a benefit of the scheme. We can continue to discuss with the county as planning authority whether we, as an authority, do that, but in the view of the position of the authorities, as I say, our evidence is quite clear on this, and there's no evidence to the contrary. This is an enhancement and therefore does not meet the tests.
So the additional wording at condition 22 would... have you discussed additional wording? No. You can do. Right.
Madam, if I could just make a comment on what Mr Humphreys has just said. It would just be fair to say that there might well be a legitimate expectation on the part of the public who attended the Council's Planning and Regulation Committee meetings, that £50,000 would be made available for local community groups to do planting. That's not to say that it needs to be part of the planning process, but certainly I would say, as someone who was at those meetings, that would be the public expectation, that the council as a corporate body would deliver upon those things. But it doesn't mean to say that we need it to be secured under Section 106 or condition.
So you're saying you need it secured one way or the other?
So, Madam, I'm saying that we would, if the view of the applicant is that it's not necessary from a planning perspective, that is fine. But it was a commitment given at the planning committee meeting by the council as applicant, and I think there will be an expectation outside the planning process that it is observed. But that is outside the planning process.
Yes.
It's not to be included within it.
So if there's no Section 106 and no condition, if I take Mr Humphrey's view, how would it be secured? Or would it perhaps not
Madam, the county, and we're both representing the county in different aspects of its legal entity, is perfectly capable of saying to the local community, look, actually we're going to devote a certain sum of money to some local enhancements, and that's what we're going to do, and you can apply to us and draw down on it. All we're saying is that the Secretary of State should not take that into account, and we will make that very clear in our closing. And the reason for that is because the districts won't accept any sort of obligation. A Section 106 then is certainly is just internal. It's not, wouldn't be enforceable. How would we enforce it against ourselves? But it doesn't need to be. Because we're not asking you to take it into account in any event. As to there being a legitimate expectation, I'm not sure I agree with that. I don't understand there to have been any reliance by people on such an expectation, but in any event, even if there was, we intend to carry it out.
Thank you. Anything further?
No, other than to say, obviously, our very firm view was that this was important to a lot of local people and others who were at the committee meetings.
Number 33, it talks about the replacement lagoon. Have I got the right one? No, sorry. Right. It discusses the lagoon, and you want details of the replacement lagoon to be submitted to and approved. And I've just really wondered, firstly, is it the lagoon on the power station site? Is that the one that's been referred to? It's not very clear to me.
Yes, I believe it's the RWE lagoon as it's termed.
Right. Can we just, in the wording, replacement lagoon at some, just so it's clear?
Add something to make sure it's clear.
Because there's another one, I think, being impacted. And then, do we know what information is sought beyond what we've already got? Because I think I've seen cross sections and the location. We've got the biodiversity details. We've got landscaping details. What's required, or do we simply need a condition saying the replacement lagoon, as shown wherever, shall be constructed in accordance with the approved details prior to the opening of the development? Do we have a view on that?
Sorry, Madam. And it may be that I've not entirely recall exactly where that detail is. If the detail is all there, including, you know, cross sections and gradients, I was thinking depth, you know, of a lagoon. You logically have something that showed how deep it's going to be.
There is.
If that detail is already there, then I would agree you probably don't need any
just-
further detail to be submitted.
Okay, can I ask the applicant just to look at that wording then and just have a condition requiring the implementation of the
Yes, we can look at that.
information? Thank you. So 34 is this noise barrier at Appleford. I think it came up in evidence from the noise witness, actually. Is that, and actually what that's referring to is whether the noise barrier can be located on the, adjacent to the carriageway for motorised vehicles and providing that separation. So you've got the cycle and pedestrian route.
I believe that's correct. It's essentially saying that an investigation should be done to see if that is desirable to move that barrier adjacent to the highway, and then the cycleway and footway would be beyond that.
Yeah, okay. Thank you. I understand that now.
Madam?
Sorry.
May I make a little comment on an area
Certainly.
here which is obviously close to the area of evidence that I proposed, where we talk about exploring the possibility of relocating. Can we also add and the noise effect of relocating? And if in the last paragraph where it's possible, details of any proposed change to the noise barrier, could also that be and the noise effect of that change?
Does the applicant have a view on that?
Yes, do you mean the noise effect for the people using the cycleway and the walkway? I mean, the idea is that we would move the barrier so that they are separated from the
I would imagine that the noise barrier is to cope with the transmission of noise beyond the boundaries of the road and footpath as well. So it would affect dwellings which are below and adjacent to the scheme. So it's the noise emanating from the scheme as a whole and how that affects the closest dwellings to the scheme.
So she'll set out the reasons if it concludes it's not possible. Perhaps say the submission should set out any implications.
Yes, the thinking would be that there must be a purpose to considering moving the position of the noise barrier, and that must be a noise effect or noise benefit anticipation. So let's include what the noise effect will be in the report of to move or not to move.
I think it was Ms. Scott said that that it would look at whether they would be looking at that issue, but I agree we need to probably have some reference in there. So I think the reference should be by relocating it, probably in the first part make some reference to any changes to the noise assessment. Mr. Mitten.
So, Madam, you asked about the matters that would be taken into account here, and I've thought of certain matters. Obviously, Mr. Humphries will comment, but in addition to reducing noise, which is the principal reason for doing it, of course, consideration given to visual appearance and the visibility of the barrier. The suitability of the ground, presumably, and the suitability of the ground in terms of supporting the structure and the current use that would be displaced, if any.
Sorry, Mr. Mitten. Are we talking, you're talking about the condition 34? That
Yes, I am, yes.
So,
yes. Because you'd asked what matters should be taken into account quite properly.
should take into account.
All we've got at the moment is the noise impact, and clearly...
I don't think we've even got... I don't think that's even actually specified. It refers to the noise barrier.
Yes, true.
So I think we need to probably look at the wording of that.
Which is the noise effect point that Mr. Hancock's made.
Yes, I think we would agree it is both the landscape and the noise effect that should be examined and explained in this condition.
Right, so I think we do need to look at something to do with the wording. I don't think there's any difference between the parties as to what it's trying to achieve. Mr. Humphreys, do you have a...
I was just going to say, I'm not convinced that there's a huge landscape difference. We're in effect talking about moving the barrier from
the edge.
Here, the eastern side of the cycleway, whatever it is, 3 metres, 2 metres to the western side of the cycleway. I don't think that makes a huge landscape difference. Obviously, we can take into account the noise difference, but I'm not sure if what Mr. Hancock is saying is what the difference of moving the barrier 2 metres or 2.5 metres or whatever it is from here to there means for people over here. Obviously, one would carry out the assessment. I'd be pretty surprised if it makes any difference at all. It does mean that in that section of the route, the barrier will be further over to the west. In this section of the route, the whatever it is, 2-3 metre high barrier will suddenly switch to the other side of the cycle lane, and then presumably switch back later, and that I would have thought would just be slightly incongruous and not have any material benefit for anyone, to be honest. But we can look at it.
So the purpose of doing it is the wrong one, sorry.
I mean, we've said we would consider moving it closer to the carriageway, i.e. from this side to this side. It says explore the possibility of relocating it because it will be, in the middle of the development.
Who did the suggestion come from? The council or the planning authority? Sorry.
I believe, Madam, I'm happy to stand corrected, and I've not got it open in front of me. This is one of the conditions again that was put forward by the applicant and reported to the September committee as one of the reasons to deal with their previous reasons for refusal. So my understanding is this arose from the applicant suggestion at that time, but I'm happy to be corrected.
But I think if it
so
did,
the
in
reason,
response
sorry,
to
the reason put
concerns,
forward for it is to reduce adverse noise effects and protect the local landscape character and visual amenity. And then obviously there's a policy reference. And I think I just wanted to... So you think it came from the applicant?
Well, that's my recollection, but I don't have the document in front of me. But it's one of the documents that is before the inquiry.
Mr. Humphreys.
I think this was in response, however, to... It wasn't our original proposal. This was in response to concerns being expressed to it. And it doesn't say we will do it. It says we will explore the possibility of doing it. I think Mr. Hancock's making the very good point that, well, hang on, one ought to understand whether it makes any noise benefit. I'm not the expert on that, but that's why I asked, does it mean for the cyclists? It might for the cyclists, but it's hard to believe it would make a difference to residents, or a material difference to residents.
So I think given the reason there, and I think the fact that it might make a difference to cyclists as well, might make the cycling more attractive along that
Yes,
section.
we have no objection to it. I'm just trying to
No,
put in context what we're talking about here.
I think the other concern, just reading it again, is that if it concludes it's not possible, it needs to explain why. If it is possible, any change should be submitted to and approved in writing prior to the commencement of the construction works, required pursuant to condition 7. I've lost track of what 7 is.
Yes.
Myself out of order.
And what we'll do is we will have a go at wording this. I think the suggestion is that we look at not only whether it is physically possible, but whether or not there is any noise benefit, and clearly that's not worth
So
doing it if there is no noise benefit.
yes, and so condition 7 also refers to this condition, and it might be that something that there could be something put into condition 7 that requires that assessment. 7 is about the noise barriers and noise mitigation measures, and it might be more appropriate to roll it up with that if noise is the main consideration, or if we're leaving it in, I think the wording does need to be adjusted to some extent, because should be submitted to and approved in prior to commencement of any construction works. It also needs to be implemented if we're going to go down that road as well, not just approved.
Madam, it does seem to us that your sort of suggestion that this might be covered by condition 7 is probably correct, because that requires details submitted subject to the consideration of 34 prior to the first operational use of each part of the development. Noise barriers, etc., 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 shall be installed in accordance with the details that have been submitted to and approved in writing by the county planning authority. So that seems to provide for us to do that, and that is a specific noise-related condition.
Mm-hmm. Sorry, Mr. Mitten, you were about to say something.
Thanks, Madam. Yes, I completely agree with that about it being incorporated into condition 7. However, I think the importance of this in the context of the whole process and members of public's engagement with this at the various planning committee meetings was that there was a real concern for Appleford Village, and that's why that condition specifically referred to that, and that therefore reference to Appleford Village should be made in condition 7.
I think that's probably the way forward, the simplest way forward. Okay, Mr. Hancock. Thank you. So condition 35, I've just put a note to see, 35 is about the noise monitoring equipment at Appleford. I've got a note to see the council's comments. I can't recall what they were. So it's 35, isn't it? So it's condition 7 on the council's comment list. So is this from the local planning authority or one of the districts? No?
Madam, I don't know, I'm sorry, because I've only looked at the conditions for today, so I'm not familiar with all the documents before the inquiry, but have you got the minutes
I've got
of the planning committee meeting?
Well, what I'd like you to look at
September.
first, if it's document Q3, and it's PDF page 2, and it's at the bottom of that page, and so this is something that Mr. Perriam circulated, and it's one of the districts actually has made the comment, so it must be Mr. Butler because it's of where it is. So you're talking that you make reference to condition 9, and I think that refers to the original condition 9. I'm not sure. And there was suggested, it's about adding vibration, noise and vibration.
That's what our environmental health officer was asking for, yes, to include vibration in the condition, just not just noise.
Vibration, and then that's the same for the reason. So does the applicant have an issue with that? And it's in the context of Appleford, I think.
Madam, may I add another comment?
I'll come to you in a moment, Mr. Hancock. If I forget, remind me. I just want to get the view from the applicant first. Is it Mr. Maddox?
Yes, sorry, Madam. So on the subject of 35, I believe it was intended to cover noise only when this was suggested in the September committee, rather than noise and vibration.
Right.
And I believe the intention was to locate some during construction only.
Yes, that is correct.
That's the point you were going to make.
It was, yes, that's right.
Okay.
I'm sorry, I don't know whether that is before the inquiry, the minutes of that meeting.
It will be. I don't have the document name. I think it will be an L. I can't remember. So it was noise only.
And I believe you had during construction, and I believe you had another comment about what the proximity to Appleford Village means. Was that?
Sorry. What was your comment about Appleford Village?
I thought you had commented on wording that suggested proximity of Appleford Village and what that meant. Is that correct?
I think that's another issue, yes.
Ah, sorry, apologies.
That Appleford Village should be... Is it a... You've got to submit the details to be approved, so I think that Appleford Village should cover that myself. But Mr. Hancock, what was your comment?
Yes, it seems to apply, it suggests details of the noise monitoring equipment, but I would also suggest it needs to be a programme of monitoring that's included and to which the equipment is used. So that can probably be covered by standard noise monitoring procedure, professional practice. There's plenty of documents that could be referred to just to pick up what is actually, what measurements have actually to be carried out and under what regime using this equipment. So I think just a simple reference to a standard method of monitoring.
We would probably cover all of that detail in the required noise and vibration management plan, notwithstanding my comment about vibration just now, which is required as part of the KEM. So I don't know whether the specific...
And it's for the duration of the construction works, right?
Presumably, Mr. Maddox, that will also the precise locations agreed between the owners of those locations, if they're a back garden or whatever, the locations will be agreed and discussed.
I believe it would have to show, because we've obviously not determined where that would be.
Yeah. Good.
So in terms of the condition itself, do we Programme of monitoring. Does it need amending, and is there general agreement that vibration's not necessary? I know, Mr. Butler, that's come from your environmental health officer. Is that in relation to piling, or you're not sure?
I can only assume it is to do with piling. If there's any pile foundations needed crossing that area, then that's when I would expect.
Other than that, are there any other amendments? Are there any other amendments to that? Amendments to that condition?
No.
No. Thank you. So 36 is the carbon management plan. My only comment is that I've put the wording in, the reason in, I think. I got that right, sorry. Yeah. Yeah. It says every subsequent anniversary thereafter. Is that in perpetuity, or is that for a set number of years?
We did agree that maybe that isn't. It would make it undischargeable because it would be presumably till the end of time. So we suggest that a time period, say 10 years, is added to the condition.
Thank you. Has anyone got anything else there? No? That's agreed. Thank you. And then the other one that I think we need to look at that's not on the list is the Maze Properties wording. I don't know if you've got anything to hand
Yes.
there.
Madam, on that, I just need to literally update myself by speaking to Ms. Reynolds. Could we just take our sort of short break now, and I'll just sort of find out what the latest.
Okay. Just
play
before we
is on
do,
that.
are there any other conditions that anybody wants to raise? No? No? Okay. So what are we talking about, 10 minutes?
10 minutes, yeah.
10 minutes. Okay. We'll just take a short 10-minute break then. Thank you. Are we ready or not quite?
Yes, madam, I think so. So the Maze property condition, it might be worth starting by just looking at one of the general arrangement plans. So there's a plan, I think it's D.01, and it's the first plan in that group of...
The one with the back hill roundabout?
Yes, that's the one. If you look at that, you'll see the new proposed back hill roundabout, and it has 4 spurs coming off it. One of them to the south west, and you'll see between the A4130 and that new spur, the area of land called Maze Proposed Development. Maze property have an existing planning permission for the development of that site for a mix of commercial uses, I think sort of roadside type uses, and within that, it was granted on the 11th of March this year for roadside services with all matters reserved for future approval other than access, which will be taken from the part implemented planning permission for a new road junction with the A4031, and that's another permission, and that's in effect a side road that comes off the A4031. Yeah, it's sort of approximately it's that. Yeah, you can see on the plan I'm showing you Maze proposed development. In the top right-hand corner of that, there are 2 sort of hollow lines that come in. The permitted access for this new scheme is along that alignment. And
sorry, can I just be clear? So I've got the plan you said. There's 2 accesses. It says private accesses to Maze development. Is that what you're talking about?
No. In the top right-hand corner of the Maze property site, you'll see two sort of almost parallel lines that come in from the A4130. Do you see those? Those are, in effect, the 2 sides of a new side road that is, as I understand it, permitted and give access to the new permitted development on the Maze property site, and that access would come in and then would go into the Maze property site. It would have a sort of a further side road off to the west, to the left, into the Maze property site. There was an alternative plan that was put forward with that application, which I'm not sure of its status, but which was a sort of plan which showed how their permitted development would work if Hif1 was granted planning permission. And that alternative access in effect shows the 2 private accesses to Maze development sites shown on our plan. In other words, it is consistent with the Hif1 scheme. Since and that's been the Maze development was granted planning permission, that they have another application which is currently undetermined. And that's for another form of development which slightly rearranges the access so that now the access into the Maze development site comes in from the south east corner of the Maze development site. So in other words, is not consistent with what we've shown in our planning application. That application by Maze is undetermined. They do not have permission for that.
Mm-hmm.
What Maze property want to achieve is for us to in some way change our scheme with the two accesses you can see on that general arrangement plan so that it is consistent with the new undetermined application which is before the council. Madam, our position, my position, but this is all being negotiated, is that I'm reluctant, I have to say, to advise the client to amend its application with its accesses into the Maze development site on the basis of it needing to connect into a scheme which does not have planning permission. Now, this new undetermined Maze planning application shows, as I say, an access in the southeast corner of that site, but because of their site ownership, it does not go all the way to our new leg off the back hill roundabout. In my view, the solution to this is that in the event that the new Maze proposed development is granted planning permission, rather than amending our scheme, which will be before the Secretary of State, that what we do between us is apply for some additional planning permission for a new access from the spur off the back hill roundabout, you know, whatever it would be, a few meters into their new proposed development. That, in my view, can be secured through a private agreement between us that would determine who applies for that, who gets that permission. I can say that provided there is permission for the alternative site access that Maze want, I don't think the council has any problem with implementing that rather than the scheme that is we're asking the Secretary of State to permit here, the Hif1 accesses. We're obviously entitled not to implement part of our planning permission and could implement some other planning permission. Now, that's the sort of background. Now, what you have, however, from Maze, and you will have seen it, a proposed condition, is something that says, notwithstanding condition 2, that's above, and the details of the proposed 2 private accesses to the Maze development, linking that land with the southwestern arm of the new back hill roundabout, as shown on the plan we've been looking at. No development shall take place, none of our development shall take place until a revised plan has been submitted to and approved by the County Planning Authority, showing the replacement of the two private accesses with a single private access located towards the southern extent of the Maze proposed development land, together with a new shared pedestrian cycleway to the north of the single private access and south of the proposed balancing pond. The development shall be carried out in accordance with the details. Now, what this in effect does is say that we can't carry out any of the development of Hif1 until the County Planning Authority has granted planning permission for a revised access into the Maze development site to serve a development that does not have planning permission, and for which, for all I know, there may be planning objections. And as I say, I'm extremely reluctant to advise the client to so condition Hif1. But having said that, I make it absolutely clear we have no difficulty with the concept of there being an agreement that if planning permission is granted for this alternative location, a separate planning permission for this alternative location for a private access, and providing we have not already built that part of the Hif1 scheme, that we would implement that planning permission rather than this small part of the Hif1 planning permission. So that is the issue that Ms. Reynolds and others are trying to negotiate in terms of some sort of side agreement. But as I say, at the moment, my advice to the client is that a condition in this form is unacceptable.
So in terms of, there's an existing planning permission and there's no issue with that, is that correct?
There's an existing planning permission, but it seems to come off this existing road that has been granted planning permission but not fully implemented. I think they may have started.
I saw some of it on
Yeah,
site, I think.
Exactly.
Yeah.
And, you know, that is there. I think Maze have perfectly properly recognised that with the Backhill roundabout coming, it makes sense then to connect into that. The accesses we show are consistent with what they had previously indicated, but they're not consistent
And did I
with this
get
latest application.
the date of the planning permission? I had the 11th of March. Was it 24?
Yes.
It was. Right. So it's a recent, very recent planning permission.
Yes, and
So
that's the one off this existing road that's been started to be implemented but not obviously built out.
And in terms of this second application, has it
Sorry,
been...
Mr. Butler apparently is the case officer, so he may be able to tell you more.
Sorry for clarification, Madam. What Mr. Humphreys is saying is correct.
Right.
Just to clarify that the 11th of March 2024 permission is an outline planning permission.
That's an outline. Thank you.
And as Mr. Humphreys was explaining, it shows an access effectively directly from the A4130 as it stands at the moment. The A4130 exists at the moment.
Does that have any, just on a separate point, does that access have any, we've got a toucan crossing almost by those accesses. That's probably something I should have picked up earlier, but assuming that's all okay, the
Yes.
second application, has it been in for a long time or is it quite...
I can clarify that. I believe it came in February.
Oh, so it's very recent, is it?
Very recent. It's not an application I've had a chance to look at in any detail as yet because of my involvement in the inquiry. But having a brief look at it this morning, it's an... Sorry, I'll let you continue writing. It's an outline planning permission, as Mr. Humphreys was explaining. It's for... it's a retail food store an electric vehicle charging station and drive-through restaurant, which are the same uses that we permitted in March. And say it's an outline application, and the application form states all matters are reserved. So that would include access is reserved as well. So that's merely for your for clarification. Hopefully that might help Mr. Humphreys and his team.
Right, so it's not awaiting it's not no resolutions.
No resolution, no
very
consideration by me
stage.
yet. Yeah, exactly.
Okay. So, is there anything you want to add, Mr. Butler?
No thanks.
Have you seen the suggested condition?
I have, and I've got no comments to add.
Right, thank you. So, Mr. Humphreys, sorry, I might have interrupted you.
No, madam, I'd in effect come to a conclusion in what I was going to say, which I will briefly summarise as saying that, you know, I advised my client that this is not an acceptable condition because it prevents us from carrying out the Hif1 development until a revised plan has been submitted to and approved by the County Planning Authority for a replacement access into the Maze land, as I say, for a development, this latest one, that hasn't even been granted planning permission, and that is not acceptable. I think the practical solution, however, is that if planning permission is granted by the Vale of White Horse for this alternative scheme, and if the access of the planning permission that is granted doesn't go all the way up to the arm of the Backhill roundabout that we are providing, then there will be a need for another short, very small gap planning permission for a bit of road between the two, and as I have said, provided that that is granted and we are asked to implement it before we have already started to implement that part of our scheme, then my understanding is we would have no problem with implementing a permitted access in a slightly different position.
And that in itself would require an application to Vale of White Horse, is that?
I think that would require, it would be a very odd application because it would be the short stretch from the edge of our road to the edge of their site. I don't know how many metres it is, 2 or 3 metres, but I understand there may be in planning terms, a gap between the two. And so yes, it would require a small planning permission.
From what I've seen, my understanding was that Mays wanted a single access rather than the two. Is it an access in a different position to what's shown?
Yes.
It is.
Yes, it's where you see the southern of the two things marked private access. That would become, in effect, the principal access. And I think it might involve some slight rearrangements to the cycling arrangements and things of that sort.
So it might need other changes to this plan. The main alignment would obviously be the same.
The main alignment would be exactly the same. Some of the detail.
The lagoon could probably
possibly
stay, but so it would be an application covering more than just that 2 or 3 metres. It would have consequential impacts.
Yes. Yes.
Madam, the balancing pond that's there would remain unimpacted by it. What I've understood Mace to want is essentially an inversion of the accesses that the HIF scheme provides for. So currently the HIF scheme provides for the vehicular access into the Maze site to be the northernmost of the two, the one immediately south of the balancing pond, with a secondary access further south. The proposal that Maze would like is for those to be inverted, so the main vehicular access would be the one to the south, with just a pedestrian footway at the north. That would require an amendment to the cycleway proposed, because it would continue down to the, if that was implemented, it would continue down to the southern vehicular access along that alignment. So essentially an extension of what is already there.
Thank you.
As part of the Hif1 scheme.
And then just my only other, just to be very clear, assuming you reached a private agreement, you couldn't amend this scheme until this scheme vary this scheme until it had got permission. Is that, it would be a variation to this scheme? Because Mr. Humphreys, you said it was
Madam,
an additional...
I'm not sure it would require us to vary this scheme. It seems to me that we could probably apply for a separate planning permission, and we would just not implement some very small parts of this planning permission, and we would implement we would implement that new planning permission.
I understand that, but to have a new access joining a road that hasn't got permission, I don't know how long the Secretary of State will take.
No, we would have the permission for the fourth arm, if I call it that, the southwestern arm of the Back Hill roundabout. That would exist, because that doesn't just serve Maze property, it also serves the Minscombe proposed development as well. We're just talking about the two little private access ways off that. It's a question of providing a different access arrangement into Maze from the fourth arm of the Back Hill roundabout. The fourth arm of the Back Hill roundabout, as a generality, does not change.
Okay, thank you. So I understand that as your position.
Yes, Madam, as I say, I've given you my advice to the client on that. Do clients always take my advice? No, they don't always, but that's my advice to the client. That's my position.
Thank you. Does anyone else want to add anything? No? Okay. I think that's everything on condition. Mr. Woolley.
Mention one matter before you adjourn, Madam. I'm told that today is the deadline for the county to respond to the Freedom of Information request about the traffic flows on the A4074 near Newnham Courtenay. Assuming that becomes available, we hope to make it available to the inquiry before it resumes.
Okay. Obviously, as you're aware, I'll need to understand why that's relevant, which you probably won't know till you've seen what's in it.
That I can cover in my closing submissions.
Okay. I think we'll deal with that when we return. Do we know where we are with the Freedom of Information request?
Sort of indirectly, in that it's dealt with, I think, by the county's Freedom of Information sort of team or unit, and so they were doing, but I can confirm, I believe today is the day. Obviously, insofar as it relates to those flows along through Newnham Courtenay, in effect, you've unofficially already had all that information. But insofar as it relates to anything else, I, to be honest, don't know about that.
Okay. Okay, so probably, Mr. Woolley, if you've got the information, if you've got any doubts about submitting it, maybe if you and Mr. Mr. Humphreys can actually discuss it before we start,
certainly.
And hopefully have an agreed position on it as well. And if you disagree, obviously a reason why, that would just save inquiry time on Monday. We've got not Monday, Tuesday.
Tuesday, yes. I don't propose to come here on Monday, madam.
No? Okay. So we will then not have to spend so much time because we've still got quite a lot of closing submissions. I know it is just closings, but there's quite a lot. So is there anything else? No? Not as short a day as I'd hoped, but we're there, I think. So we'll adjourn till 10 o'clock on Tuesday, and then that's focused on closing submissions. Okay.
Thank you, Madam. And as you're aware, I'm not here Tuesday
You're
or
not
Wednesday,
here.
but I will be here on Thursday.
Okay. Thank you, everybody.